Committee will come to order without objection. The chair is authorized to declare recess of the committee at any time. This hearing is entitled Examining the SEC's Agenda, Operations, and FY 2018 Budget Request. I now recognize myself for 3 minutes to give an opening statement, but I warn everybody I'm going to take a lot longer because there's unanticipated news. First, before proceeding to the purpose of this hearing, I do want to note for all my colleagues that as we begin this hearing today, in 318, B318 of this very building, the Rayburn building, our friend, our colleague, that great American hero and patriot, Sam Johnson, is being honored by having that very room, B318, named after him. I think we all know that he is a decorated war hero who served his nation with great courage, great valor in Korea and in Vietnam, and spent 7 years enduring torture in the infamous Hanoi Hilton. But we also know him to be one of the kindest, most gentle souls in this institution, and he has many distinguished accomplishments for the people of his district and from his position on the Ways and Means Committee. I personally look forward to visiting the Sam Johnson room soon, and I hope all my colleagues look forward to that as well. This morning, we welcome Securities and Exchange Commission Chair Mary Jo White. And I will take a little longer due to news that we received last evening that the chair intends to step down at the end of the Obama administration. I do wish to acknowledge on behalf of all that Chair White has now completed over 2 decades of distinguished public service as a U.S. attorney, as chair of the Securities and Exchange Commission. She has brought an incredible amount of professionalism to her position. She is known for her independent judgment, which is greatly admired and respected. I also want to personally thank her for being one of the few witnesses from the administration that has never requested an artificial time limit on her attendance at a hearing. She has always made herself available to this committee, and she has always made herself available to all subcommittees. She has indeed epitomized what it means to be an accountable agency to Article 1 of the Constitution, and she is to be commended for that. Also, she has always submitted her testimony on a timely basis. If there were cash and valuable prizes we could award you, Madam Chair, for such an accomplishment, we would, but I'm sure we would breach a number of ethical and legal considerations by doing so. She has always made her division and office directors available, also at capital markets subcommittee hearings. And again, the accountability and transparency that she has brought to this office is greatly admired. But just in case you're lulled into a false sense of security, Madam Chair, we still have some concerns and we still have some disagreements. So it has been almost a year since your last appearance here, and there are many subjects we are eager to discuss. Chief among them are the SEC's ongoing failure to develop a capital formation agenda. Notwithstanding 2 very minor rule changes approved last month, the SEC has done little to promote capital formation since Congress passed the Jobs Act in 2012. The failure by the SEC stems in part from the Commission's refusal to act on recommendations made by its Small Business Capital Formation Forum. I encourage the SEC to review these recommendations and act on those that will help small businesses to access the capital markets so they can improve, grow, and provide economic opportunities for all American workers. Also languishing at the SEC is a directive passed by Congress requiring the SEC to simplify its disclosure regime. The FAST Act, which became law nearly a year ago, requires the SEC to eliminate or reduce burdensome, duplicative, or outdated disclosures. Chair White, I also know that you are under enormous pressure from those who are intent on politicizing the SEC's disclosure regime, but you have an obligation to follow the law and not appease extremists whose ideological objectives have nothing to do with the SEC's core mission. In addition, the SEC's failure to require the electronic delivery of mutual fund documents is disappointing. How can the SEC force public companies to engage in social, environmental, or sustainability disclosures while simultaneously promoting the wasteful use of paper, the cost of which is ultimately borne by investors? It's time for the SEC to move into the 21st century and allow for the e-delivery of mutual fund documents. Finally, we need to discuss the SEC's budget request. As I look at the disturbing national debt clock before me and to my sides, I see no need for the SEC to receive a pre-funded escrow account of more than $290 million for a potential move of its headquarters. The SEC will have to increase its fees to pre-fund the move, which is nothing less than a tax on capital formation. Furthermore, the claims that the SEC is underfunded are not supported by the facts, since the SEC's budget has increased by a whopping 325% since the year 2000, an increase that the American people do not enjoy. Moreover, the SEC's current budget of $1.6 billion does not account for the money in its reserve fund, which can include up to $100 million, plus another $25 million in unused funds that carry over from the previous fiscal year. Finally, Chair White, and this is most important, whenever there is a transfer of power from one presidential administration to another, there is a temptation for federal agencies to rush pending rulemakings to completion as a way of cementing the policy priorities of the outgoing administration. But this type of midnight rulemaking is neither conducive to sound policy nor consistent with principles of democratic accountability. As there are currently 2 vacancies at the Commission, absent an emergency, given your current reputation and legacy, I would strongly urge you to respect the results of last week's election and resist the temptation to finalize any regulations, including Dodd-Frank Title VII regulations, in deference to the right of the incoming administration to set its own priorities upon taking office in January. I now yield 5 minutes to the ranking member.
Thank you very much, Mr. Chairman, and thank you, Chair White, for being here today. I'm truly disheartened to hear that you will be stepping down, Chair White, considering there's so much at stake and so much to fight for. But I'm encouraged because of all of the kind words that Chairman Henselin had to say about you when he started his testimony today. That's the nicest I've heard him be to you and any of the others in our oversight agencies since we have worked together here. So,
would the gentlelady yield?
Yes, I will yield.
If anybody on your side of the aisle wishes to depart, I'll say very kind words about it.
Well, I'm sure since you have said such kind words about Chair White today, you'll be asking her to please stay. Please don't go. Also, I'm appalled that the reaction on Wall Street to Tuesday's election is record highs for bank stocks as the industry rallies on the news of a massive, destabilizing, lawless agenda. But let me be clear, short-lived increases in the stock market are not the same as real, hard-earned economic growth. And the demise of the regulations that Wall Street is cheering are the very regulations that have made our consumers, investors, and economy safer and more resilient. In fact, just yesterday, Wells Fargo's stock closed at the highest price this year on the expectation that a Trump administration and Republican Congress will erase its culpability. Indeed, we're facing uncertain times, and at the forefront of that uncertainty is a president-elect who does not have a coherent or consistent stance on anything. We don't know if he's building a wall or just a fence. We don't know if he's repealing Obamacare or cherry-picking some provisions that he now seems to support. We don't know who he is, what he stands for, or what kind of president he will be. We cannot rely on anything he says because it changes from one day to the next. So when Mr. Trump talks about financial services reform and dismantling Dodd-Frank, what does he mean? Does he mean letting the Wall Street banks he's so indebted to write their own rules? Does it mean repealing the fair housing laws that the Department of Justice sued him over decades ago? Does he want to repeal investor protections and make it harder for the SEC to go after bad actors? Does he want to gut the Consumer Financial Protection Bureau, despite the agency being the strongest champion of everyday consumers? Does he mean breaking up the banks by reinstating Glass-Steagall? In that regard, I'm sure we could find some common ground. Does he mean closing the carried interest loophole and ensuring that private equity fund and hedge fund managers pay the same taxes that everyday Americans pay? Will he pay the same taxes that everyday Americans pay? I am curious to see how Republicans in Congress react to this wide-ranging, sometimes progressive agenda. Mr. Trump said he is not beholden to Wall Street and other special interests. Yet here he is with rumored appointments of Wall Street insiders and their friends in Congress to run his administration. Mr. Trump also said he wants urban renewal and to ensure that African Americans have access to loans to start small businesses and get mortgages. Yet, he appoints a leader of the white nationalist movement as his chief strategist in the White House, and he himself has made racist, misogynist, and xenophobic comments. Chair White, even though you're about to leave, I hope you will share with this committee and the incoming administration the important role the SEC plays in our financial system. I hope you will explain the importance of a well-funded cop on the securities beat and strong investor protections. The SEC has been the victim of woefully inadequate budgets as a result of Republican obstructionism for years. Despite the crucial role that the SEC plays policing our ever-expanding financial markets, we're now at a crossroads where Wall Street is poised to profit off of American consumers and investors. If we enact these special interest wish lists, or if the SEC weakens its rules at the expense of the greater good, our economy will go right back to the darkest days of the financial crisis. I hope that common sense will prevail. With that, I yield back the balance of my time. And Chair White, I apologize for not spending more time on SEC and a lot of time on Mr. Trump, but that's what I'm going to be doing for a long time to come. I yield back the balance of my time.
Chair now yields 2 minutes to the chair of our Capital Markets Subcommittee, the gentleman from New Jersey, Mr. Garrett.
Thank you. Thank you, Mr. Chairman, and welcome once again, for the last time, Chair White, to our committee. And before I begin, let me just echo the many of the sentiments, the positive sentiments, expressed by the Chair Henseling regarding your tenure at the SEC. Every SEC chair receives criticism when they sit here and around from both the left and the right about certain policy positions that they take. But recently, you've had to endure, I would say, an unprecedented level of attack from certain groups and from individuals as well, who have called out your integrity and called out your professionalism and put them into question. They've even gone so far as to call for you to break the law, if you will, or be fired for your refusal to follow their direction. Chair White, it's clear from these many hearings that we've had that you and I disagree on certain policy issues on more than a few occasions. But I can say this here, that I have never, ever questioned your professionalism. I have never, ever questioned your integrity and your devotion to doing the good in your work. It is a difficult job that you had, and you've handled it very well. And you've done so for all the right reasons. So I just want to take this moment to say thank you for your service and for your thoughtful approach, for which you have tackled a number of issues, in particular the area that I've spent a lot of time on, the equity markets, which continues to be an important priority for the SEC. Now, having said all that, I did mention that we have disagreed on certain policy issues a couple times, so let me highlight a couple of those before we go off. Despite the SEC having an important mission to, as you know, facilitate capital formation, the SEC, I believe, has still not organically, within itself, developed a capital formation agenda. and instead, really, I believe, has relied on almost exclusively on our committee and the full committee and Congress, if you will, when it comes to trying to change some of that and trying to modernize some of those areas of securities laws for the benefit of the small and the medium-sized enterprises. These are things that we've talked about. This despite the fact, as the chairman was just mentioning, the SEC's budget has not only continues to grow, but the agency has again requested a substantial increase without detailing how it will expand those on these missions. Finally, I also remain concerned that the SEC has not done an adequate job to assert its jurisdiction, and this is important, and expertise in the capital markets when other regulators attempted to trample on your turf, whether it's the Department of Labor or prudential regulators over FSOC or the FSB. So with that said, I hope that in your testimony today, as you wrap things up, that you will address both of these issues and others to ensure that Congress and the SEC is actually prepared to carry out its threefold mission before Congress decides whether the agency deserves that increase in budget. And with that, Mr. Chairman, I yield back.
Gentleman yields back. Today, we welcome the testimony of the Honorable Mary Jo White. Chair White has previously testified before this committee on many occasions, so I believe she needs no further introduction and has received her deserved accolades. Without objection, Madam Chair, your written statement will be made part of the record, and you are now recognized for 5 minutes to give an oral presentation of your testimony.
Thank you very much, Chairman Hensarling, Ranking Member Waters, members of the committee. Thank you all also for your kind remarks. I appreciate it very much. It's my honor to serve. And again, thank you for inviting me to testify today on the current work and initiatives of the SEC, as well as on our fiscal year 2018 preliminary authorization request. As this committee knows well, the SEC is a critical independent agency that is charged with protecting millions of investors and overseeing the strongest and safest markets in the world. I'm very proud of the Commission's hard work and many accomplishments since I became chair in April 2013. We've achieved record numbers of enforcement actions and examinations each year. We've completed dozens of transformative rulemakings, including fundamental reforms to money market funds, credit rating agencies, and the securitization markets. We've built important new regulatory regimes for capital raising, critical market infrastructure, and municipal advisors. And we have put in place enduring frameworks for our future work in areas that are central to the SEC mission: asset management, equity market structure, and disclosure effectiveness. Our latest results in enforcement and examinations exemplify the agency's high level of performance during this time. In fiscal year 2016 alone, the Commission brought over 850 enforcement actions, an unprecedented number, secured over $4 billion in orders directing the payment of penalties and disgorgement, and we performed approximately 2,400 exams, a 7-year high that reflects a smarter, more efficient program. The strength of our enforcement program can also be seen in the kinds, complexity, and importance of our cases that span the markets and the securities industry, including numerous first-of-their-kind actions. As this past year also shows, the Commission, with only 3 members, was able to continue to pursue a very consequential set of policy measures designed to protect investors, strengthen the markets, and open new avenues for capital raising. Since I last testified, the agency has, for example, advanced major rules addressing important equity market structure issues, including the transparency of ATSs and order handling practices, while moving forward with a comprehensive assessment of other fundamental structural questions. And this afternoon, the Commission is scheduled to consider in an open meeting approving a final plan for the critical consolidated audit trail. Over the last year, we have also continued implementation of a series of proposals to address the increasingly complex portfolios and operations of mutual funds and exchange-traded funds. We adopted final rules to modernize the data reported by both funds and their advisors, completed rules for enhanced liquidity management by funds, and adopted a proposal for new controls on their use of derivatives. We also adopted new rules to better enable businesses to raise capital through local and regional offerings, and advanced our comprehensive review of the effectiveness of our disclosure regime, including through several detailed proposals. And along with several other rules prescribed by statute, we finalized critical components of the regulatory regime for security-based swaps and established new standards for the clearing agencies that stand at the center of our financial system. In addition to our many discretionary initiatives, the Commission has now adopted rules for nearly 80% of the mandatory rulemaking provisions of the Dodd-Frank Act and all of the rulemakings directed by the Jobs Act. We've also made significant progress on the rulemakings required of us late last year under the FAST Act. While our enforcement and our rulemaking work are perhaps the most prominent examples of the agency's achievements, the imperatives of our mission are also carried forward by our exceptional and diverse staff every day, from reviewing thousands of filings each year to assessing complex submissions from exchanges and other SROs to incisive economic analyses and publications. And as publicly reported today, the Commission has, for the second year in a row, received from GAO an unmodified audit report with no material weaknesses or deficiencies on the SEC's financial statements. The Commission today is, I believe, a stronger and more effective agency, and I'm honored to have led it during this time of progress. But significant challenges remain if we are to adequately address the growing size and complexity of the securities markets and the ever more sophisticated financial services industry. And it is critical that the SEC have the resources required to discharge its important responsibilities, the new ones, and many others we have long held. I deeply appreciate that we must be prudent stewards of the funds we are appropriated, and we strive very hard to demonstrate how seriously we take that obligation by the work we do. At the same time, our resources are insufficient to fulfill our extensive responsibilities to investors and our markets, and cuts to the SEC's budget would seriously imperil the progress we have made and diminish our ability to fulfill our mission. While more remains to be done, the agency's accomplishments in the last few years across the range of its vital responsibilities have both been impressive and enormously important to investors, the markets, and capital formation. For that, I want to thank first and foremost the exceptional staff of the SEC, as well as my fellow commissioners, present and past. And I want to thank the chairman, the ranking member, and this committee as a whole for your continued support, which will allow the SEC to fulfill its essential mission for the American economy. If I might, on a personal note, as the chairman has indicated, I did formally announce yesterday that I would complete my nearly 4-year tenure as chair of the SEC at the end of this administration in January. It has been my high honor and privilege to serve. And while I've not yet actually done my David Letterman top 10 list of what I will miss most, I'm sure my appearances before this committee will be somewhere on it. But more seriously, as an independent head of an independent agency, it is to be expected that we have had areas of agreement and areas of disagreement. But I very much appreciate the professionalism and the courtesy of the chairman, the ranking member, and the committee generally, as we have together grappled with the challenges before the SEC that are so important to the American public. Thank you, and I'm happy to answer your questions.
Thank you, Chair White, and the chair now yields himself 5 minutes for questions. Chair White, as you know, significant attention has been devoted recently to liquidity concerns in our U.S. and global fixed income markets. When you testified last year before us, I asked you about the regulatory impact on bond market liquidity. And at the time, you testified that while, quote, no question there are concerns about the liquidity in the fixed income market, at that time, a year ago, you could not identify a culprit. Since your testimony of a year ago, we've had some news and some evidence of the regulatory impacts on liquidity. They have become starker. On September 27th, former Treasury Secretary Hank Paulson commented that, quote, the Volcker rule solved a problem that was not a problem. We have much less liquidity in the markets. It has become much harder for financial institutions to provide liquidity. On September 16th, Douglas Cifu, CEO of Virtu, one of the world's largest electronic market makers, announced that his firm would no longer invest in certain bond exchange traded funds, certain ETFs, because the underlying securities had become too hard to trade, thereby eliminating sources of liquidity as banks continue to reduce their roles as market makers. On October 7th, the value of the British pound plummeted from $1.26 to $1.18 in a matter of minutes. During trading in Asia, with some electronic platforms recording trades as low as $1.15, the Wall Street Journal attributed this extreme volatility in part to a lack of currency traders in the foreign exchange markets. So since your last appearance, Chair White, have you been able to determine whether regulations such as the Volcker Rule and Basel III capital and liquidity requirements are a contributing cause of the continuing decrease in liquidity in the fixed income markets, particularly the corporate bond market?
The short answer to that is no, but we continue to study it very, very carefully, really, frankly, globally, and at the SEC as well. As you know, economists at the SEC from our Division of Economic and Risk Analysis are charged by Congress with actually studying and reporting to Congress on the impact of regulation generally on market liquidity. I think that report is actually due in May of 2017, but I know your
Well,
staff—
Chair White, does the recent data concern you? Because it has been a year, and it's disappointing that there still are not conclusions.
The data does concern me. I think I said that, I think, at my last testimony as well, and the issue, the overall issue also deeply concerns me, and it's something I will say that I go back quite frequently to our staff to try to drill down on what, obviously what we are reporting to Congress, this committee in particular, each quarter is on corporate bond liquidity, primary market as well as secondary liquidity levels in the bond markets. And that essentially, although some decrease obviously in dealer inventories, but by most measures, there's not been a deterioration. I will say this.
Well, I think you are aware, Chair White, that many economists believe that, frankly, the next financial crisis very well could be triggered by this bond market illiquidity phenomenon. So as you are soon to depart your stewardship and chairmanship of the SEC, I would simply request that resources be focused on this. Now, during your appearance before the committee in March of 2015, I asked you and other members of the Financial Stability Oversight Council to conduct an analysis to see what systemic risk could be posed by this diminution, a significant diminution of liquidity in our bond market. Since that time, has the SEC or FSOC, of which you are a voting member, conducted any analysis of the systemic risk that could result from a lack of liquidity in the corporate bond market?
Clearly, we are studying at the SEC. I mentioned our dear economists, as well as others on our staff. In terms of FSOC, again, there have been working groups on the staff of FSOC looking at that, but there's no definitive conclusion there. I know some work is going on in different working groups there.
Again, I would commend to you, this is an area that is deserved of laser-like focus, and I hope the appropriate resources will be devoted. Again, it has been at least over a year since these concerns have been brought to your attention and the attention of FSOC. One last question. During the adopting phase of the Volcker Rule, 5 regulatory agencies had the ability to interpret, examine, and enforce compliance with it. That has led to overlapping and conflicting guidelines. To what extent are the 5 adopting regulatory agencies trying to coordinate efforts concerning the Volcker Rule?
We still have our working group that we've talked about before that meets quite frequently, both on interpretations and also coordinating enforcement. As you know, that's assigned to the different agencies. So we're working very, very hard to try to coordinate and be as consistent as we can possibly be.
Time of the chairman is exhausted, and now we will yield to the ranking member 5 minutes.
Thank you very much, Mr. Chairman. I'd like unanimous consent to enter into the record a story from the Washington Post from August 10th of 2016.
Without objection.
This story, for those of you unfamiliar, recounts a legal deposition from late 2007. Donald Trump had sued a New York Times reporter for defamation, alleging that the reporter lied in his book about Trump's net worth and his general lack of success in business, something we know that Trump is very sensitive about. Now, because Trump sued the reporter, it allowed the reporter's lawyers to get access to Trump's business documents. As the Post story documents, through the defamation trial of this reporter, it became clear that it was Trump that was guilty of the lying. In fact, the reporter's lawyers caught him in lies 30 separate times. He lied about sales levels in his condo buildings. He lied about how much it cost to join his golf clubs. He lied about his amount of debt. He He lied about his number of employees. He lied about how much he was paid to give a speech at the Learning Annex, overstating the payment by 1.5 times. He lied about needing to borrow money from his rich dad. And he tried to pin the blame for some of the lies on a co-author of one of his books. He lied about facts that were simple to disprove, things easily verifiable by searching documents and public records. Now, this lawsuit that Trump leveled against the reporter was thrown out by the judge and was denied an appeal, so there was justice in this case. But this man is now, unfortunately, our president-elect, and I expect him to continue with these distortions. Only now our nation is at stake, and when he is a thin-skinned bully, I hope he doesn't lash out on the freedom of the press or on peaceful protesters, but we stand ready to protect our sacred American freedoms, and will hold him accountable, starting with this committee. Chair White, I bring all of this up because you were the lawyer in the 2007 case that helped depose Mr. Trump and expose all of these lies. This deposition I mentioned is part of the public record. So, is the Washington Post story true? Did Mr. Trump really systemically misstate, invent, and lie about business information? And was this lawsuit ultimately thrown out by the judge on the case?
I don't think I think it would be appropriate. You're correct, Ranking Member Waters, that I participated in the defense of that reporter who wrote the book that you mentioned. I actually argued the appeal myself, and the case, the reporter prevailed in that case. I don't think it would be appropriate to comment on, specific, statements during the litigation.
Okay, so I just wanted to confirm and place in the record that this case did take place and that you were part of the deposition. So now you know firsthand, we all know firsthand the character of the man who's going to be our next president. Mr. Chairman, now I understand why Chair White is stepping down. Oh, he left. Oh, can't tell him. I yield back the balance of the time, Mr. Garrett.
Gentlelady yields back. Thank you. I recognize myself now for 5 minutes. So, Chair White, you and I have both talked, but we also had correspondence go back and forth about the SEC's implementation of the FAST Act, which was to simplify and modernize disclosure requirements under Regulation SK. And as you know, there were a couple deadlines for the SEC to meet under the FAST Act. So the first was to propose simple rules to eliminate outdated disclosure, right, which you have done, thank you. And the second deadline, which is due next month, we're in November and December, is for the SEC to issue a report to Congress on further ideas to modernize disclosure. So in going through the testimony today, on page 12 of your testimony, you say, quote, staff has also completed a study and report on how to further modernize and simplify regulations SK as mandated under section, so on forth, the FAST Act. Can you just apprise us of what report that you're referring to and what report are you referencing? And I say that because, to the best of my knowledge, I have not received and our staff has not received a report or study on that.
I think I noticed the same reference in the testimony, and was not cited. There was not a footnote cited to it. I believe that reference is to the report that's due November 28th to Congress. Okay. And the staff has, completed certainly a draft of that report that is with our commission now for review. It is a staff report, but as is customary under our procedures for most staff reports, they're provided to the commission before they're provided to Congress. Gotcha.
So my next question, I guess, is the easy follow-up. Then is so the deadline that is established in the FAST Act of December.
I think November 28th, I believe.
As far as you're concerned, that's going to be met, and so we'll be.
I certainly believe so. Yes.
Before you leave here for good. Congress will have that report.
I hope long before I leave here. I hope it is to you on November 28th.
Fine. Moving on, the SEC, as you know, has the Equity Market Structure Advisory Committee. That term for that committee, which has been around for a while now, right? It was slated to end in January of 2017, so next year. So the next question is, do you anticipate renewing that committee for another term, or is that something that you're leaving to your successor to handle to renew?
I certainly think it should be renewed. I think it's been very, very useful.
Sure.
I think it will be useful going forward.
Right.
I'll be discussing it with my commissioners. I think it's maybe a February 2017 date, but in order to renew the charter, we need to deal with it now. So I'll be discussing that with my commissioners.
Okay, so for all intents and purposes, from where you sit, yes, go forward with it.
It certainly, in my view, it certainly should go forward.
All right. And when it's done, are there other industry representatives who are not there now who should be, such as retail brokerage or anybody else?
There's been a lot of discussion about the composition. The initial composition, I think there's 17 members, was actually approved by the full commission when it was a full commission, actually, of 5 members. And so obviously our goal was to get balance and representation, but clearly there are retail brokerage is one area where I think it's represented there by virtue of knowledge of members who are on the committee, but is one area where, I think we've all sort of identified as maybe the one place we'd like to identify an actual member of the committee.
Yeah.
And then I think we've also had requests from various other folks, NASDAQ, New York Stock Exchange, to be members. That's also up to the full commission.
Okay, and so that's something you're going to throw out before you leave, as far
Well,
as...
I mean, I think we have the issue before us of the renewal of the committee. Separate from that is the membership. It's possible we would proceed
To your
by
successor.
extending it and then figuring out the membership in short order.
Okay, moving on. The SEC, another topic, Rule NMS. The SEC published its list of rules that were reviewed pursuant to the Regulatory Flexibility Act, which included Reg NMS. As such, do you believe that the SEC should continue to examine the impact of that rule on the equity markets, which is what I look at all the time, and the behavior of individual market participants? As you indicated several years ago, back in '24, you gave a speech on this topic, and yeah. I
absolutely do, and I believe we are.
In what sense?
As part of the, I sort of talk about our equity market structure review as, we have certain proposals out there on specific areas where we think we should act now, and then we have a comprehensive review of what I would call the more fundamental structural issues. Reg NMS is clearly, front and center in that more comprehensive review. Our MSAC committee is working on that.
Yeah. My time has expired. I have a bunch more as far as what I was talking about in my opening statements as far as capital formation and not being done, but again, thank you for your service.
Thank you very much.
Thank you. The gentlelady from New York is now recognized for 5 minutes.
Thank you very much, Mr. Chairman, and thank you for your public service. You've been a trailblazer and a role model to many young boys and girls. New Yorkers are very proud of your service to New York and to the country, and we thank you so much for your leadership and really groundbreaking, stellar career in so many different areas. My question to you is about a statement you made last month when you gave a speech on the regulatory regime for the U.S. Treasury market. You noted that under the Government Securities Act, firms that act as dealers in Treasury securities are required to register with the SEC as government securities dealers. But you also noted that the regulator's joint report on Treasury market volatility had found that the most active dealers in the inter-dealer Treasury market were high-frequency traders, principal trading firms, many of which are not registered with the SEC as government securities dealers. You stated, and I quote, "There is significant concern that this activity indicates that certain principal trading firms are acting as dealers, but without the appropriate registration and regulation that is designed to protect investors and the markets," end quote. So my basic question is, why has this been allowed to go on for so long? You yourself admitted that some of these principal trading firms, quote from you, are clearly engaged in dealer activity, end quote, without being registered as dealers. If that's true, why hasn't the SEC brought in any enforcement actions against firms that are acting as unregistered dealers?
I think I indicated that the data from which I drew those observations came out of that joint interagency study of the events of October 15th, 2014, and raised questions about whether some of those firms shouldn't be registered. I believe I also mentioned in that speech, I know I have elsewhere, that the staff is working on whether there needs to be public guidance issued as to where the line between dealers and traders are to take account of that phenomenon. Sort of interesting in the Treasury markets, I think what's happening there is terrific, frankly, because you've got great cooperation among the various agencies, including Treasury, banking regulators, and the SEC, CFTC, working together. We each have certain spheres of authority for the Treasury markets, and I also indicated in that speech that I thought we ought to apply some of the SEC's authority to create greater transparency and, frankly, other protective measures in the Treasury markets as well as the equity markets.
Okay, thank you. My second question is about the statements that you've made several times over the past years. You've suggested that the SEC should rethink its 2009 diversity disclosure requirements to provide more useful information on the diversity of boards and their nominees, and you directed your staff to review the existing disclosures. At my request, the GAO reviewed these requirements and found that the information provided by companies is inadequate and unhelpful to investors. And I'm wondering if your staff reached the same conclusion. And because of repeated studies that indicate more diverse leadership helps companies avoid so-called groupthink and make better strategic decisions, many investors want access to data on board diversity as they make investment decisions or exercise their voting rights. Leading institutional investors petitioned the Commission in March of 2015 to revise the diversity disclosure. They suggested that a simple matrix could make the disclosure simpler for investors, issuers, while providing investors with actionable data. So do you think, where does this stand and where are you? I do want to say that in this GAO report, it showed that women were 16% of boards, and if they upped their activity significantly, it would be 2040 before there was any gender balance. The GAO report also provided research from private firms that showed when there was gender diversity, the bottom line was better for investors. And my office has received requests from institutional investors, major investors, on getting more accurate information on gender diversity. I even went so far as to put in a bill that merely added another line that said, just disclose how many women are on your board. It would not be in any way burdensome to industry. It's just another check or another number that would be added. And this is information that investors, significant stakeholders and investors are asking for. They're asking for this information. So I wonder where this stands with the activities
and the
of your administration.
gentlelady's time has expired, but if you want to answer that.
I'll be very brief. As you know, I'm a very strong proponent of diversity on boards, and I'm aware of the studies you indicate, which I think are quite telling. Where that stands is the staff has studied it, and they are preparing a recommendation to give to the Commission. Pretty far along in that in terms of trying to provide more meaningful disclosure along the lines you indicate.
Do you think you'll receive this before you?
I do not. Unfortunately, I do not. I mean, will they receive it before? They may well receive it before. I don't think there will be a proposal before I leave.
Okay, thank you.
Gentlelady's time expired. Thank you for the answer. The gentleman from Texas is recognized.
Thank you,
now
Mr.
for 5
Chairman.
minutes.
Chair White over here in the corner. There we go. Yeah. You and I are kind of in the same situation. This is probably my last hearing with you, and I want to thank you for your service. Yesterday, the SEC held its first ever FinTech forum, and which included panels on recent innovations in investment advisory services, trading, settlements, and clearance, and investor protection and capital formation. So, after this forum, what's the next step at the SEC in the FinTech space?
First, it was a very, very useful forum. We've been quite active in that space in terms of doing significant outreach. Some issues are sort of on our plate right now, some are for the future. I formed earlier this year in effect, a FinTech working group that I've directed to make quite targeted recommendations, quite specific recommendations to the Commission on what the next steps should be at the SEC, both in terms, to some degree, of regulations that we have now that may apply to certain fintech activity, how we can appropriately foster innovation, but also obviously protect investors in the space. The three topics we really discussed yesterday, and the ones we've been most focused on, obviously the distributed ledger technology generally, and the settlement and clearing space, the so-called robo-advisors, that's not the name they like to apply to that, but how automated providers of advice, and it's not only automated often, can comply with their duties, fiduciary duties on the Investor Advisors Act, Investment Company Act, and then marketplace lending. Those are kind of the three big areas that we're focused on, although our folks in the Division of Corporation Finance have also been reviewing and passing on companies that, for example, would actually issue digitized securities. So we essentially will receive those recommendations, I don't think imminently, but I think in the next few months, and then decide, what we need to do next in terms of concept releases, rulemakings, or just giving more clarity to entrepreneurs as to, the spaces that they may be in and need to comply with.
So this working group that you've formed, the recommendations that you heard yesterday, will it be their responsibility to respond to and to?
Well, certainly what we heard at the forum will be part of the analysis, part of the input of the analysis that they are doing. The recommendations will come from that working group to the commission. They're doing much broader outreach than just what we heard at the forum, but it was enormously useful input for that set of recommendations that I expect to receive.
And in your response to my question, one of the things that I think is a common theme that I think concerns a lot of us about what's going on at the SEC is you mentioned regulations, I think 2 or 3 times when I mentioned the fintech space. And I think one of the things that we're also looking for is facilitation from the SEC on how do we make these markets better, and not how we immediately, the first thought that we have is how do we going to regulate these folks. And so, what I would hope is, I think the forum was a positive step. What I would hope is that if you're going to put together, or your successor put together working groups, it might be kind of handy to have people that are in the industry, a part of that, and spend some time focusing on, how we facilitate those, because as you know, there's some exciting things going on in that space, and some things going on that could revolutionize the way that we do, some of these functions.
And I essentially agree with that. And I really said that yesterday. I did some opening remarks that's, you don't necessarily jump to regulation. I mean, we did put out also a concept release, I think the end of last year, request for comment on the transfer agent space, for example, and asked questions just like that. So it's a matter of, there's some exciting things going on out there that really will improve the markets, improve things for investors. We certainly don't want to be thwarting those, but obviously we have to make certain that, that it's a protective, that investors are protected in that space. I mean, the market lending space, for example, to make sure that, if in fact there are investors that are providing that money through offerings, that they're being given the information they need to have. So I think it's a mixture of things, but certainly not with a mindset of we've got to regulate. There may be some rules we need to do. There may be some clarifying we need to do, but we certainly have the encouraging innovation lens that we are applying to that as well.
Since most of these are non-depository institutions, should the SEC be the primary point from a regulatory perspective for these companies? I mean,
I think they range in terms of the nature of the institutions that are involved, but I certainly think we should be taking a primary role, yes.
Thank you. My time has expired.
Thank you. The gentleman's time has expired. Gentleman from Massachusetts, welcome back.
Thank you, Mr. Chairman and Ranking Member. Much appreciated. Madam Chair, congratulations. Sorry to see you departing, but thank you for your service to your country. I think you did a remarkable job under the circumstances, and I have a feeling that as far as your critics on this side of the aisle go, I think they will miss you very shortly. I think we can all expect that. I know you're wrapping up, but on market structure, I had proposed a maker-taker conflict of interest reform act of 2015 last year, and I know there was a competing proposal among you've got an equity market structure advisory committee that had a little different wrinkle on it. It didn't go as far as what I had proposed, but it talked about lowering access fees, which is a good thing. But I don't think it really got at the issue of the routing, the conflict of interest in routing certain trades. Going forward, as you wrap up, is there anything percolating that might actually come to fruition in your closing months?
I don't know if it'll come to fruition quite in my closing months, although we are really in response, I mean, not just in response, but including in response to that recommendation that you referenced, which really is to do a pretty comprehensive pilot. It may not do everything. We also have an outstanding proposal on more transparency and order routing, too, which I think is very important.
Yeah,
proposal that's out there. The staff's working very hard on it. It will be the staff's recommendation to the commission as to the next step to take. And clearly, we take very seriously, and I think it's a good proposal that we've gotten from from our Equity Market Structure Committee. But obviously, we will be studying that as to whether to do it in the first instance. Although I think you've got a lot of support for doing such a pilot in that space, and then what precisely the component should be. I can't tell you that something will come out before I leave, but we're still driving it.
Okay, and the question of resources, over the past while, at least over the last 6 or 8 years, we've had a defunding or a lack of resources for your agency. Can you speak to that a little bit about just the practical impact of that defunding, and also as the cop on the beat for our financial markets, and also morale-wise in terms of trying to retain the best and brightest people at the SEC?
And just to go to the latter point first, it's so important that we're able to retain the best people and attract the best people with the expertises you need to protect investors and to be that strong cop. I mean, I've said this before. The biggest challenge I've had as chairman of the SEC, and there are no want of challenges as chairman of the SEC, is just how significantly under-resourced we are. And I appreciate we've gotten budget increases, but look at what our responsibilities are, how extensive they are, how complex they are, how much they've been added to. Mm-hmm. Look at the volume in the equity markets. Look at, for example, I think 10 years ago we had 17 examiners for every $1 trillion of assets under management by registered investment advisors. We have 8 now. And I talk mostly in terms, because it's so stark, of our investment our responsibility to examine investment advisors. And I've done everything I can, and appreciate the support I have gotten when we get funding to really increase the number of examiners smartly in that space, and I've done that. I've actually increased the staffing in that area of our OC program, National Exam Program, by 20% between transferring some from the broker-dealer side, where we have FINRA that's also operative, and some of the funding that we have been given. But we're still in the position, we're smarter, we use risk analytics, but we examine 11% of those 12,500 registered advisors every year, 35% of the assets under management. On the broker side, where we have FINRA, it's about 50%. And so it's a big, big investor protection issue. Of course, it affects morale, because you have some of the brightest, most dedicated staff in the world at the SEC, and their lodestar mission is to protect investors. And when you can't examine those advisors who are dealing with those investors and have a duty to those investors to act in their best interests, you're not able to do the job that you are assigned to do by Congress and so much want to do in order to fulfill our mission.
Well, thank you again. My time has expired. I just want to thank you again for your service to your country. Thank you.
Thank you.
Thank you. The gentleman's time has expired. Gentleman of Missouri.
Thank you, Mr. Chairman. Ms. White, we're over here. Thank you. And thank you also. I want to add my kudos to those of my colleagues for your service and your responsiveness to this committee. It's very, very much appreciated. So we wish you well in whatever endeavors you may pursue from here on out. Just have a comment first, and I want to ask for you to comment on it if you would. I understand that you've announced your departure, but you're still the SEC chair, and I want to raise one issue in hopes that you'll give it some thought. It's on credit agencies. I know the SEC has taken steps to address the entrenchment of incumbent rating agencies, but I think more needs to be done. We should facilitate broader competition amongst credit agencies and encourage those acting on behalf of U.S. investors to do the same. I know Senators Scott and Franken, among others, have raised this issue with you, and the SEC's own work has shown that This lack of competition has the potential to harm investors. It's your job to protect investors, and I hope you'll give this issue all due consideration. I'm certainly going to be in touch with your successor and with SEC staff on this issue as we go down the line. But I realize it's a general statement, but if you'd like to comment on it, I would certainly offer you that opportunity.
Just briefly, I mean, clearly that's an area we continue to focus on. We've done a number of reforms in the credit rating agency space that I think are very important to have done in terms of governance and transparency, conflicts of interest. We've seen some improvement in competition, but it's still a major issue. It's a very difficult one to come upon an optimal solution for it, I think, in a both a cost-effective way, but also in a way that actually deals with the issue that you're trying to, correct for. But it's something that our economists continue to study, as well as our policy staff divisions.
Well, I know if you watched the movie The Big Short, there was a lot of, it was very graphic on how the problems were created, what was going on, and obviously this is a point that we need to shore up with regards to, allowing investors to have confidence in our bonds and the ratings of those. So certainly appreciate your consideration. The chairman a while ago mentioned also something about pending rules. I guess my question would be, do you have any requests from the administration, or do you guys have in the SEC any ideas of any midnight rules that you're getting ready to propose that we need to be watchful for, or we're going to come in the back door here that we need to be thinking about?
No, essentially, our agenda, frankly, I set out our agenda for 2016 in February of 2016 at the conference called SEC Speaks, which is where chairmen usually talk about the agenda. We've advanced a number of those priorities already. I said we'd do as many of them as we could. And we've also, we've basically set the agenda for the rest of the year and into January.
You don't see a divergence?
I don't see any last-minute rushes to, I do intend, to carry out the agenda I outlined in February 2016 as much as I can.
Okay. In the Bloomberg report this morning, there is a report. Its headline says, U.S. consumers are increasingly defaulting on loans made online. And the story talks about delinquencies and defaults are reaching key levels known as triggers for at least 4 different sets of bonds. Reaching those levels will force lenders or underwriters to start paying down bonds early. I guess my first question is, are you aware of this with regards to the online lending loans that secure these bonds, and they're having some problems?
I'm certainly aware of the reports of those issues. Obviously, our space is the investors in the space, not the lenders, but obviously they become relevant in terms of what are those assets underlying the investments.
I would say they become very relevant.
Very relevant. I agree. I didn't mean to minimize it at all.
In the article, it talks about breaching these levels can force a company to divert cash flows from assets to paying off bonds instead of making new loans, which often means it has to find new, more expensive funding or to scale back its business. They're going to force some of these bond folks to change their business model, and to me, it's very concerning. Are you considering any actions to prop this up or to investigate further, or you're just kind of watching from the sidelines?
We continually, are, studying the space to the extent it really impacts, what we are doing and the offerings made, in effect, to raise the money to, provide the funds to lend. Disclosures of,
What kind of notices or disclosures are required by these bonds when these things trigger? That they have to send those out to the investors, or
when they're offerings, so that they do have to make various disclosures. Sometimes they're public offerings, sometimes they're private offerings, but you have to make material disclosures to investors. And so, and I think I mentioned that yesterday, actually, at the FinTech Forum. Very, very important that information, talk about the underlying loans in a very accurate way.
So I'm sure you're monitoring this, if this is the case. Where do you see this going? You see this just as a blip on the screen, or is this a bubble getting ready to burst, or you see this as a trend, or just what do you see?
I think, without putting sort of an umbrella characterization on it, I think we've seen an increase in those concerns in the last year. Now, that may be because more information is available on it now, but it's something we're watching very, very closely.
Thank you.
Okay, thank you, Mr. Chair.
Gentlelady from New York is now recognized for 5 minutes.
Thank you, Mr. Chairman. Chair White, I want to congratulate you for finalizing the mutual fund data reporting rule. The rule will give the SEC an important window into the fund industry, while at the same time preserving the ability of the industry to manage portfolios in a manner that serves clients without prescriptive constraints. Given the vast amount of new information that the Commission will be receiving, what special resources is the SEC committing to protect the data from cyber criminals who will want this proprietary investing information?
I think, and it's been in our budget request for certainly the last, the years since I've been here, because I've really prioritized our data security obligations, both with respect to the new information we're going to be receiving there, the existing information we have. It's also relevant in what we're doing this afternoon with respect to the consolidated audit trail. So we're devoting significant resources there. Our budget request for 2017, and when it's finalized for 2018, you will see resource requests specifically for that purpose.
Thank you. Yesterday, Commissioner Piwowar said the SEC should take the lead on fintech regulation. Last year, I sent you a letter expressing my concern about regulatory uncertainty in this area and to better understand the needs of your agency now and in the future. I know you're stepping down soon. Do you have any final thoughts on this rapidly growing industry and the role you envision the SEC playing in the next few years?
Well, I agree with Commissioner Pivovar that the SEC, in its spaces that fintech touches, and there are a lot of them, should certainly take the lead and be proactive, and I think we have been. I mean, some spaces, and I think if I remember your letter addressed at least in part market lending platforms.
Correct.
We're uniquely among the regulators that are actually involved in those sets of issues focused on the investors, as I just mentioned, if in fact that's how the funds are raised to lend. Where we don't act is really in terms of the lending standards or the actual loans that are made. But I see the SEC playing a major role going forward in all the fintech spaces that we have any jurisdiction over.
Well, I'm glad to hear that. Thank you. You and your fellow regulators have spent years crafting the Volcker Rule to balance the needs of market makers and underwriters with the mandate to eliminate proprietary trading with federally insured funds. What happens if the Volcker Rule is eliminated and banking entities that have access to the federal safety net are once again allowed to make risky proprietary trades?
Well, I think it's I guess I would maybe answer that a little more broadly, that I think the reforms that are contained in the Dodd-Frank Act have been enormously important to strengthening our financial system and for the protection of investors. Obviously, the Volcker Rule is a significant component of that. So I think we're much stronger and more resilient than we were before the various reforms in the Dodd-Frank Act. And so, I certainly would not want to see those rescinded or repealed.
Thank you. And I was happy to hear about the SEC's recently adopted rule regarding interstate security offerings. This has the potential to cut red tape and help many small businesses raise capital where they live and work. Outside of interstate offerings, are there any other areas the SEC is or should be looking at to streamline small business capital formation?
As you know, we fairly recently, under the Jobs Act, reformed, it really expanded Regulation A+, the crowdfunding regulation. We have a proposal that's outstanding on what the definition should be of a small reporting company, so that if there was an adoption of that, you would have more smaller companies that were able to scale disclosure. Our disclosure effectiveness review tees up various issues about scale disclosure for smaller businesses. We were very pleased to recently adopt the intrastate amendments to our rules to make it easier for small businesses to do intrastate offerings, including in the crowdfunding space. But it's something, we have our forum, our annual forum coming up this week, actually. We'll be talking about more avenues to try to facilitate raising capital by smaller businesses.
Thank you, and thank you for your service.
Thank you very much.
Kelly's time has expired. Mr. Huizinga is recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate that, and I too want to echo the sentiments of my colleagues, and thank you for your service and your efforts in here. And I think you have tried to come in and be as honest and forthright as you sometimes possibly can within the constraints of of what we're dealing with. I am concerned about something that has been brought up by the much-cited Commissioner Piowar, concerning activism really overriding market soundness and in some cases common sense about how we regulate and make sure that good business decisions and regulatory decisions are behind that. And I mean, we have tons of examples, but pay ratio and conflict minerals, political spending disclosures. He talked about this. So how do you guard against that in these closing days is really, I guess, kind of my question.
Well, I mean, I think there's several things you've grouped in there. I mean, a couple of them are congressional mandates, and I've talked about that before when I've testified. I do regard my job as the chairman in part to carry out congressional mandates. They're passed by Congress, but we carry them out. It's our obligation to. We try to do it in the most cost-effective way we can, as consistent with our mission as we can, but they really come from Congress in terms of, and then there are various things.
How about those things that don't come from Congress?
Yeah, and then I was about to say, the various things we don't do also, because of the concerns that you mentioned. I think it's, and as far as I'm concerned, since I've been chair, we know what our mission is. I make a judgment as to, from myself, as to what's the right thing to do. We take, obviously, input from all constituencies about that, but then ultimately make that decision based on our mission, protecting investors, the markets, capital formation.
Very specifically, I guess, then, I mean, there's 2 commission seats currently open. Blaine Lukemeyer, my colleague, had started kind of going down this road, and I guess I'd like to get as definitive an answer. Well, I'd like to get a definitive answer. I'll stop, period, on that. But there's reports that regulators are trying to, quote, rush to finalize the incentive compensation rule prior to President-elect Trump taking office. Will you commit to us here that you will stay any commission vote on that rule until after the inauguration? Because this is a
Yeah, I understand. It's a multi-agency, and basically, I think the reproposal was issued by the agencies in May of this past year. The staffs are clearly, working through the comments on that. It's not sort of a new issue, so I can't commit as I sit here what the timing on that would be, other than to say that.
Well, regardless of the
I hear
timing,
what you're saying.
Yeah, regardless of the timing. I mean, they may or may not have it done. The reports are they're rushing to try to get it done. And what I'm asking for, I guess, is the commitment from you that you will then not vote on this or not allow a vote on this from the SEC to implement that before there's a new president.
Look, I say 2 things, and I'm going to be very straight, as clear as I can on this. I mean, I don't think any rulemaking benefits from it being rushed. It's hard to do it right. It's hard to do it optimally, and I've really tried, even in joint rulemakings, to make sure that our economic analysis comes into play and our expertise comes into play, and I certainly will commit, to do that. But I think I can't judge in a vacuum the next 2.5 months, and I don't mean to, but that's, as I sit here today, that's the commitment I can give.
So if you were satisfied, we got another minute and 15. We can keep going back and forth, me asking and you avoiding it. So if you are you saying if you are satisfied that they have gone through and properly vetted this, then you would have no problem moving ahead with that? Or,
I mean, again, I don't know what's going to be in it. I mean, I want to be satisfied.
They don't know either. I mean, that's
no, but they's us too. They's me too, right? I mean, in the sense that I have to put it on the agenda to vote, and obviously, what is always at issue there is the content of the rule, obviously, in terms of to be satisfied with it, that I think it ought to go to the commission.
Well, it's both content and context, correct? I mean, as long as there's, the content.
Let me say it this way. I understand completely the sensitivity that you're raising, in terms of the time period that we're in. I will say that this is something that, has clearly been sort of proceeding, apace all year. It's not something that's all of a sudden proceeding apace. But I'm absolutely sensitive to what you're raising.
Okay, so.
As far as I can go.
15 seconds. Okay. You are not, are you willing to commit to not vote on this?
No, I can't give that commitment in a vacuum. That I can't do. But I think I've said all I can, but would hope, well, I think I've said all I can say.
Well, and I guess I would like to hopefully emphasize your view that rushing into these things is a bad path to go.
I think rushing into anything is, but certainly I take your point on that.
Okay. With that, I give it a shot. All right. Thanks, Mr. Chairman. I yield back.
Okay, so we're going to rush over to the other side then. Mr. Scott, now recognized.
All right. Thank you very much, Mr. Chairman. Chair Lady Joe White, I want you to know that I think that you have been one of the very best chairman of the Securities and Exchange Commission in the whole history of the SEC. And we all want to thank you for your service. You're smart, so tough, and many people don't know, but as a former prosecutor, you showed that toughness when you took on John Gotti, the big mafia boss, brought him down. And you showed that toughness when you dealt with the world terrorists that attacked and bombed our World Trade Center in New York. And that same toughness you brought to the SEC as you really stood up and supported Dodd-Frank as our main instrument to prevent any future taxpayer bailouts of the financial sector. So I say congratulations on a job well done. Now, let me just ask you something. About 6 weeks ago, this committee had a hearing about Wells Fargo and the scandal. Now, it's my understanding that almost 3 years ago, the SEC did an investigation regarding the aggressive cross-selling of Wells Fargo. Is that true?
Again, I can't comment on any investigation we did or
I don't
we
want
might
you
be
to.
doing, but I think what you're referring to, at least the reports that I've seen, and again, I'm just commenting on the reports that I've seen, the media reports that I've seen, refer to our Division of Corporation Finance, and their comment letters. That's not our enforcement staff. It's
I just want to get for a matter of chain that a few years ago, perhaps as many as 3 years ago, somebody informed you that about this cross-selling. Now,
again, what the SEC looks at, I mean, the actual cross-selling practices obviously is not in the SEC's jurisdiction.
Right.
It's the banking regulators.
Right.
Disclosures are within our jurisdiction, though, and I think that's where that's
but-
emanating from.
And now we have new reports that the SEC is again investigating Wells Fargo's cross-selling practices. Is that true?
Again, now I can't comment on whether and what we're investigating. Again, you know what our jurisdiction
All
is
right.
to
Well,
investigate.
give me what I'm trying to get is you're doing your job, and I certainly respect your comments on that. But I think it's very important to show that the SEC has been on the case and has been dealing with this in the best interest of the American people. So could you just maybe tell us, tell the Financial Services Committee how the investigation is proceeding? What can we expect? Any conclusion? Is there any input you can give us as to where you
I'm
are?
afraid I really cannot, because we don't comment on whether we're investigating something or what we might be looking at if we are. I just can't do that in any case. Yeah.
Okay. Well, let me go to this point. I'm the ranking member on the Commodities Exchange and Derivatives Swap Subcommittee, and I have been constantly assessing the numerous rules surrounding derivatives in terms of equivalency on the world stage. My committee handles the jurisdiction of the CFTC, and of course you're involved in that as well. Now, a major concern I've raised is on the equivalency issue, particularly with the European Union. I want to know what the status of that is going forward from your knowledge. And I also want to get an idea of how you feel this exit of the largest market within the European Union, Great Britain's exit from the European Union, impacts this issue of equivalency.
First, I think, as you know, the derivatives markets are uniquely global, so obviously that's why all the regulators internationally have been dealing with these issues. SEC's own cross-border proposal on the securities-based swap space is under the rubric of substituted compliance. When can we and can we not accept other jurisdictions' rule to satisfy our rules? Our staff's involved in those discussions. The CFTC has been, as you know, more involved earlier, more extensively in some of those discussions. And in terms of the UK, that's still sorting itself out, I think. I mean, the concern is that it needs time-wise also to be put back on track so those rules can actually, work together and be effective. So, but I guess we're in the stage now where everybody's very focused on those priorities, but the discussions still go on.
Thank you
Well,
very
thank
much,
you, Mr.
gentlemen.
Chairman, and best wishes to you.
Mr. Duffy.
Thank you, Mr. Chairman. Chair White, welcome again for your last appearance with us as the chair.
Said last, right? Now, can we?
Yes.
Okay.
I want to join my colleagues. I have not been the biggest fan of the administration, how they've complied with Congress's requests for information, how witnesses have come in and testified before this committee, I think has been obstructionary at the least. But that has not been the way you've run the SEC, and you have been frank and honest and cooperative. I think you've come in and tried to answer the questions that we've asked to the best of your ability, and I think you're a standout in how you have run the SEC and how you've engaged with Congress, and I want to thank you for that. And I know that's probably at risk of making your next 2 months more challenging that we heap such great praise upon you. But I think it's a job well done, and to be clear, we don't agree on everything. And that's understandable. But I think, again, you've done an outstanding job. I do want to drill into, and you can pick up our concern with what's going to happen in the next 2 months. And we always get concerned about the lame duck session of a presidency and a rush to implement a whole bunch of new rules. And I think the better practice would be to wait and let the new administration come in. We've kind of done a little dance today as you've had questions, but what rules do you want to see finalized? So not this, but I'm talking about you personally. What do you want to see finalized in the next 2 months?
Well, I think, again, I mentioned it earlier. I mean, we're not rushing, in my view, anything. So, I mean, as far as that's concerned, did set out the agenda, earlier in the year, and frankly, our agenda for the rest of, this year and into early January has been set, for some time. I think other than this afternoon, which has been sunshined and publicly noticed when we will be considering approving the final consolidated audit trail plan. I don't think we've publicly noticed, the others that, we've talked about internally in terms of scheduling. I mean, some that I have mentioned in terms of sort of, year-end goals include the capital margin segregation rules under Title VII, something, by the way, that all of my commissioners have firmly supported prioritizing, my current commissioners and my prior commissioners and myself. So that's, that's one that I've mentioned publicly. I mentioned, I think, in my oral testimony that we do have an outstanding derivatives proposal in the asset management space, and I've mentioned publicly before that that is a priority. We're also looking very carefully at what the chairman mentioned in terms of 30E3, in terms of the providing mutual fund reports electronically. That's something that when we adopted the reporting rule, but for that I said we were very focused on trying to have the staff give us a final recommendation as to what to do by year end. I think those are the ones I've mentioned publicly.
Okay, and we've blown through most of the timelines set out in Dodd-Frank. We're 6 years on. You're now a year in, basically, to the statements that you made at the start of the year, that we go 6 years, and then the last 6 weeks, I think would not be the best practice. I would like to see you hold off as much as possible, unless it's an emergency for the next administration. But that is just my opinion. I only have a minute and a half left. Quickly, I want to thank you for your work on the tick size pilot program. We worked on that in the House. You saw what happened here with an outstanding vote in this committee and on the floor, and took it upon yourself to implement this pilot program, and we're grateful for that. We want to give our small companies greater access to capital. But as you've heard, Some participants worry that the data will expose their trading strategies. You've heard that as I've heard that. Can you assure the committee that you will ensure that the data that's provided will be protected? And can you give those who participate that assurance?
I mean, the answer, I've heard those concerns raised. I mean, the staff is all over those questions that have been raised. I mean, and I think I said before in answer to another question that, the security of the data that should be secured is, couldn't be a higher priority in every space, including the tick size pilot. So the staff's very focused on it.
And very quickly, so want to move over to shareholder proposals. Shareholders only need to own $2,000 worth of stock for 1 year to submit a shareholder proposal for inclusion in proxy materials. In addition, a shareholder proposal need only receive 3% of a vote cast the first time and 6% and 10% in subsequent years, respectively, to qualify for submission in the next year. This hasn't been updated for 50 years. Do you have any thoughts on whether we should be updating these proxy submission rules?
I certainly think, and again, I think everyone knows the sort of the press of our rulemaking agenda in the last 3 or 4 or 5, 6 years. That's obviously been discussed for several of those years. I think it's very important for the staff to refresh what their recommendations are in that space. I will say there are very divergent views on that. For example, the $2,000 threshold was originally put in deliberately small, right? So you could allow the small shareholder to have, that kind of franchise participation. But as you say, that was set some time ago, and I'm also obviously aware of the issue on how many times, and what vote do you get on the proposal. So I think you'll see the SEC returning to that. Not that they've left the study of that, but I don't think anything will come out during my tenure.
Okay, and again, just my time has expired. I want to thank you again and for your great work and cooperation with Congress. I yield back.
Thank you very much.
Gentleman yields back. Mr. Green is recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you, Chair Lady, for your outstanding service. It has been an honor to work with you, and my hope and my prayers are that you will be equally as successful in the next life as you have been in this one. Thank you. Madam Chair, if a bank, without being specific, if a bank creates a circumstance such that it gives the appearance of being in a growth mode by engaging in some onerous tactics, by giving the appearance that it has more customers than it actually has. You're in the business of protecting investors. You're the investor protector. Bank is giving this false sense of growth. Is this the kind of thing that the SEC concerns itself with?
And again, talking in the abstract as you presented the question.
Very general terms.
No, I mean, there's no question that is very much in the disclosures to public investors, we'll phrase it that way, or the accuracy of them is very much in the SEC's space. We bring cases in our enforcement division on misleading material disclosures all the time. I mean, a lot of those cases. And so, what you look at, and you mentioned, kind of was there growth or not growth? I mean, you obviously look at both quantitative materiality and you can look at qualitative materiality. So if instead of a profit there's a loss, you may have qualitative materiality issues even if it's not a big amount. So you certainly, you do apply those lenses at the SEC to disclosures like that.
And when these circumstances manifest themselves, does it take a complaint from many investors, or do you do this on your own motion, on your own volition?
We very, very often do it on our own volition. I mean, obviously, we're constantly surveilling the marketplace and the marketplace of public information. We obviously have our own data analytics, so often we do it ourselves. Often, we'll get obviously we have a very vibrant whistleblower program, so we get information there. We get it from all sources, but in terms of, we don't have to wait on a complaint to act. We're very proactive.
And when you do this on your own volition, is it published that you are engaging in this process, or is this something that happens and then we are accorded the results as opposed to an indication that the process has been engaged?
If we're talking, and I think we are, about an investigation that we would be doing in our enforcement division, for example, and I think that goes back to my discussion with the Congressman Scott, we do not disclose whether we're investigating something or what we're finding, and so you wouldn't see that until, if it did, in an action. Now, sometimes when we do open an investigation, the companies, if they're public companies, will disclose the fact that, that investigation is ongoing. I mean, again, that's their call, based on their read of the, what's required, what's prudent to do. But you won't hear from us if it's an ongoing investigation until there's a result, typically.
Well, I'm going to come back to this, but I'd like to go to another point, and I have time enough to do it. Do you find that there is a conflict between what your agency has as its responsibilities with the CFPB and its responsibilities?
I've not found that during my time as chair. I mean, obviously, we work cooperatively with all other, civil and criminal law enforcement agencies. So, I mean, could there be overlap that could, conflict is a word, I mean, you try to work out any conflict that you have in these spaces. There's an awful lot of space to cover. Different agencies have different...
You would not recommend the elimination of the CFPB, I take it?
Clearly it's been a very active enforcement agency, and I think, there's a need for a lot of active enforcement agencies.
Thank you. My final comment will be this. Wells Fargo engaged in conduct unbecoming a bank. They took advantage of people at the entry level in their business such that it benefited the people at the top of the business. As bad as that is, it also caused people who were making what they thought were honest investments based upon quality information. They allowed those people to make those investments to their detriment. My hope is, without getting into what you will do, is that Wells Fargo will be treated fairly and justly, and also those investors will be treated fairly and justly. Thank you very much.
Thank you. Mr. Pittenger, recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you, Chair White, for being with us. I must say, while we clearly would have disagreements, you have been very respectful, you've been very straightforward, you've been professional in every manner, so I commend you for your work.
Thank you very much.
And I would like to say an anecdotal reference is made to why you were leaving. Did you make the decision to leave prior to the election?
I did, and I think in the last 50 years or so, the chairman of the SEC has left when there's an election,
yes,
and irrespective of which party is coming into power. I've served for almost 4 years, so it's really normal course decision. I mean, in fact, I might have mentioned it somewhat later, but I was actually coming in here today, so I thought clarity was a good thing for coming in here today.
I appreciate you saying that. There was some inference made that you left because of some individual who was elected president. Chair White, as you may know, I led an effort earlier this year with 50 other members of Congress relative to concerns of the sale of the Chicago Stock Exchange to a Chinese government-affiliated firm. As well, just 2 weeks ago, my staff met with SEC Commissioner Pibawar on this matter, and he expressed some of the same concerns regarding the corruption inside Chinese firms, as well as their complicity and the lack of transparency within them. Given that China remains the #1 state sponsor of corporate espionage and intellectual property theft and market manipulation, we urge the CFIUS to conduct a rigorous review of this transaction and block it if it's felt it was necessary. Would you kindly comment on this and your opinion relative to this transaction and your concerns with whether a Chinese government-affiliated firm should buy the exchange, given it does play a more minor role in the markets, albeit it would be a foothold into our markets?
I think the issues that you're referencing are CFIUS issues, which is obviously not our bailiwick. We do have a process that follows that hasn't begun yet, so I wouldn't want to, frankly, comment on that or prejudge that.
I understand. Chair White, you previously noted that, in quote, in enhancing market structure, we must focus closely on the particular needs of smaller companies and their investors. What do you believe are the most significant issues that smaller public companies face in today's equity markets? For example, the reduced liquidity. You've commented on this some, but I'd like you to elaborate on that.
I mean, I think one is it's obviously the availability or not of secondary liquidity. I mean, I think our tick size pilot is obviously designed to see whether widening the spreads may help that. I also, in the public spaces, I think we have to be very focused on, are any of our regulations such that, again, they need to be there, they need to protect the markets and investors, but are they unnecessarily inhibiting companies, smaller companies from going public? I mean, that's something we're focused on all the time.
Sure, thank you. I would like to ask you that companies obtain capital through borrowing or equity financing, which we've discussed some, but do you agree that tightening of credit has made equity financing all the more important as a means of providing small companies with the capital they need to grow and expand and create jobs?
That seems to be what the data shows.
Thank you. I yield back.
Gentleman's yields. Gentleman ready?
I'm ready.
Gentleman's recognized for 5 minutes.
Thank you so much, Mr. Chairman. Thank you, Chair White, for being here. We are more than 6 years out from the passage of the Dodd-Frank Act, and far too many rulemakings have yet to be finalized, despite the ample time that has been afforded to our regulatory agencies. One such rulemaking relates to Section 956 of Dodd-Frank. This section imposes upon large financial institutions the responsibility to institute clawback policies or policies that would allow the financial institution to snatch incentive-based compensation away from executives that engage in wrongdoing. Democrats on this committee wrote to you last month asking you both to work quickly to finalize the rule and to strengthen it. I'm now hearing that this rulemaking may not be finalized anytime soon. Indeed, as it relates to the SEC, there are reports indicating that the sole Republican commissioner of the SEC has refused to grant a quorum for a commission vote when it comes to any rulemakings he objects to. That's right, the commissioner reportedly won't even show up and vote no, instead choosing to not attend the SEC meeting at all. Is it correct that the Republican commissioner has threatened to deny a quorum and thereby prevent a commission vote on any particular rules, including the 956 clawback proposal?
Every rule that I've put on the agenda, we've had a quorum for. So, the Republican and the Democratic, I'm only three, but we've all shown up for those. In terms of 956, the reproposal that was in, I think, May of this year, which is joint, but it's us, SEC as well, we moved that by seriatim, so there was no attempt to block that or not to have a quorum.
And so where is it now?
Well, what is, I think, I mentioned before, and I think it's been publicly discussed by other regulators, all of the regulators, and there are either 5 or 6 of us, it's a joint regulation, are working through the comments and working on that reproposal.
Thank you for that. Last month, Reuters reported that the SEC questioned Wells Fargo over aggressive cross-selling practices in late 2014, quoting correspondence from the Commission's Division of Corporate Finance. As you know, the bank's cross-selling practices as they related to deposit and credit accounts as well as online banking were eventually found to be unfair, deceptive, and abusive by the OCC, the CFPB, and the City of Los Angeles, to the tune of a combined $185 million fine. Can you tell the committee what prompted the SEC's inquiry into Wells Fargo's cross-selling practices 2 years ago?
Again, in terms of the practices themselves, that's obviously not in our jurisdiction at the SEC. I think what you're referring to, I'd mentioned earlier, are reports of our Division of Corporation Finance as part of their annual review of financial filings of lots and lots of companies, public companies, raising certain questions about the disclosures. But that's not, that's not sort of the content of the cross-selling practices. That's not in our jurisdiction. But I think what that is raising some questions about, I can't go beyond whatever's in the public record about the comments, but I think that's what that refers to.
So that was just routine inquiry on the part of the Division of Corporate Finance?
Again, I can't say anything more specific than I have, but it does appear to be part of that annual review process of disclosures with just questions being raised, which is a routine part of what we do, a very important part of what we do. But
And what was the outcome of the division's inquiry?
Again, I think comments, as I understand it, comments may have been, issued on the disclosure, questions and comments. I can't tell you what the outcome was in that sense of the word.
Okay, and earlier this month, Wells Fargo announced via a regulatory filing that the bank again was being scrutinized by the commission related to disclosures surrounding its sales practices. How does this differ from the 2014 inquiry?
Again, they've made the disclosures they have. I can't comment on whether we're investigating or what we are investigating. I did point out before that obviously public company disclosures, if they, are something that we, not only do we review them in our annual reviews, which is what we were talking about before, but if we have some questions about them, may come under investigation. But I can't really say anything more than that, than the company itself has said so far, and really can't comment further.
Thank you for your responses, and my time is up. Thank you.
Gentleman from California is recognized, Mr. Royce.
Thank you, Mr. Chairman, and I thank you, Chair White. Thank you for your service. Thank you also for always having your staff and yourself available. And the focus of the SEC originally was, and I think should continue to be, the strength and resilience of our markets, and I think that's critical to economic growth and to the jobs that are created thereby. But when it comes to capital markets lending, and I've got a question about the last few years and maybe some reflection that you would make, because we've had a lot of changes, major regulatory changes such as risk retention. We've had the accounting changes. We've had the prudential changes and new capital and liquidity rule, and new disclosure regimes and automated trading platforms. And all of this is occurring at the same time. And European regulators have raised concerns about how these new regulations fit together. And this is the crux of a question here, because specifically on his way out the door, EU Financial Services Chief Jonathan Hill concluded that whereas after 2008, the greatest threat to financial stability had been the financial crisis, over time, the greater threat had become the lack of growth itself. In other words, too little risk itself, in his words, became a stability risk. And then he went on to say that the crisis may have made the scale and the pace of regulatory change inevitable, but the various layers of regulation could have been better aligned. That was his reflection, and I was just going to ask you yours in terms of whether you agree with that sentiment. If we step back and we reflect on the cumulative impact of all these regulations and carefully understand what this means for growth and lending before we move forward with major changes, what would your observations be on that?
Well, I think in terms of the impact of the let me back up to a threshold. Obviously, the capital markets and innovation are built on taking prudent risk with factors fully disclosed. So that's obviously a very important driver of growth of the economy and everything else that's positive. Obviously, one has to worry about, and we do, systemic risks that could destabilize the system and obviously cause tremendous harm,
Right.
to investors. I think in terms of the impact of regulations, I mentioned a little bit earlier that our economists at the SEC are studying and will be reporting to Congress actually next year on the cumulative impact of regulations on capital formation, as well as corporate bond liquidity. And it's something we study all the time. When we do our rules, by the way, our economists do study the economic impacts, and they do look at not just the particular four corners of one rule and what you're changing there, but look, you've got these other 9 rules out there, so when you add this one, what's going to be the cumulative effect upon all sorts of economic impacts. There may be a benefit for investors, there may not be, but what's the cost of it? And one of the costs may be a cost to growth, and so you want to be concerned about that.
Right, I understand, and I think, the Financial Services Chief, Jonathan Hill from the EU, is just, in retrospect, looking at this, but at a time where, as you know, there's still more coming down the pipeline. We have discussions continue on Basel IV. We have the proposals on the fundamental review of the trading book. So I assume you share sort of that overarching goal, which I think he speaks to there, that we need to balance the goals of market stability and safety and soundness with the needs of market liquidity, efficiency, and of end users, and of overall economic growth.
I think that, at least as I view it, that's part of the cost-benefit analysis that we do. I think you have to think more broadly, as I said before, when you do that, and that's very much a part of it.
Well, I appreciate your observations and, again, your service, and thank you very much.
Thank you very much. Thank you.
Madam Chair.
Mr. Meeks?
Thank you, Mr. Chairman. Thank you, Madam Chair. Thank you for all of the hard work that you have done. And I particularly want to thank you, and I'll ask a few questions later in regards to making sure that our boards become more diverse. And I want to get into a few questions of that. But first, I want to ask you this question. I think I heard my colleague, Mr. Clay, talk about it, and a few other members dealing with this whole Wells Fargo issue, et cetera. What concerns me about it is that, especially coming out of these elections, and I heard both Democrats and Republicans preach from urban America and rural America, they are losing faith in the honesty at times of some of our financial institutions. Now, I know that our financial institutions are absolutely essential to our well-being and our way of life. But the common everyday American is, the question that Mr. Royce asked. They don't get into that to the in-depthness that I think that you have to, and what the SEC does. What they ask me on a consistent basis, for example, is how do we find out that someone is doing something wrong before it has the impact that it has had on whether it was the employees or the consumers of Wells Fargo. So I would like to ask you, as you are outgoing, what kind of advice would you give members of Congress or your successor on what we can do? Because even the Wells Fargo scenario, it was I'm hearing this often, it wasn't the SEC that discovered it initially, it was the LA Times. And so then it puts a question on where we go with reference to our regulatory agencies and confidence in them that they're going to, in fact, be there to protect the American people and to make sure the banks are honest. What would you say, or how would you?
Yeah, you're raising a lot of very, very good questions. Again, I can't comment specifically on Wells Fargo other than to say that the cross-selling practices themselves are not, they're not in other regulators' jurisdiction. I'm not saying that just for clarity. But what the broader issue that you're raising, which is really in part a corporate culture set of issues, it's in part how do we more strongly deter also misconduct in our companies and in our financial institutions. That's a function of law enforcement. I've spoken before. I'm going to speak again in a few days about things I think we need to really be considering. I mean, one of them is, enhanced penalty authority for the SEC, but more fundamentally, I think, a question we have to be focusing on is, accountability at the senior executive level for things that may occur on their watch, even if not even if they're not involved in the misconduct? And how do you sort of infuse this do the right thing culture throughout a big company? And we have codes of conduct. We've mandated those for years. Works better in some companies than others. Tone from the top in terms of what's said and even what's done may be good. I read something recently that I thought resonated with me, at least, that when you want your employees to behave in a certain way, you've got to really focus on what you're inspecting, not just what you're saying, and what you're rewarding and what you're punishing. And so if you end up with the incentives misaligned, don't be surprised when you get misconduct that's occurring. In terms of earlier detection, by the agencies, we're working on that all the time. One of the things I'm proudest of at the SEC, frankly, is the use of data analytics and all the data that's available out there to make us smarter and smarter earlier about, what may be problematic conduct. But I think it's a whole set of issues that we have to kind of think out, and Congress, I think, too, has to think outside the box about to really raise that bar of culture and compliance.
So on that, one of the things that, I get concerned, and that's why I appreciate your, the diversity initiative that you have taken with the SEC, because I think that when you have more diverse boards, you have more diverse thinking and more diverse watching at that level, because clearly that's the best way. If you got a great board, they're not going to allow these kinds of things going on where they don't have self-interest. Well, that would be the hope. But in this scenario, in one scenario, do you think that there's a conflict, or companies can go when you have an individual who is both the CEO and the chair of the board? Because then it seems to me sometimes there's no, the chair of the board can check the CEO makes, because there's the balancing act. But when you have both, it seems to me that could lend itself to something unseemly.
Clearly it raises all those issues. I guess I think, the SEC doesn't sort of take a substantive policy position on that. That's really a matter for the shareholders and state law. I guess I am, speaking for myself, though, a bit of a one-size-may-not-fit-all situation. But clearly there are diverse.
But it should be something that's considered. You look at it, when you see
Definitely
that should raise a flag to say, let's ask some questions about it to see if a red flag presents itself that needs to be done further.
Gentleman's time has expired. Mr. Holgren is recognized for 5 minutes.
Thank you, Mr. Chairman. Chair White, thank you so much. Echo much of what my colleagues have said, and do appreciate your service very much and wish you all the best. Earlier in the hearing, you answered some questions from Congressman Garrett about the work of the Equity Market Structure Advisory Committee. As follow-up, can you tell me what mechanism is in place to ensure the recommendations of the Advisory Committee are included in policymaking in the Commission? How can we be certain that the reports are not left on the shelf to collect dust, as so many are? And as you're probably aware, the Dodd-Frank Act requires the Commission to respond to recommendations made by the Investor Advisory Committee.
Yes, well, first, I was behind the formation of the Equity Market Structure Committee, and I think we formed it in early 2015, really bringing in a lot of expertise, points of view to add to what I also at least reinvigorated, I think, which is the comprehensive view of the equity market structure. And so they have been enormously helpful, I think, in keeping the focus, not that our feet really need to be kept to the fire, but we're all sort of in this in a very laser-focused way to sort of get to, concrete changes if they need to be made. So in terms of their recommendations, at the end of the day, it's really the SEC that has to decide, not the committee. But it is essentially they're dealing with the issues we're dealing with, the most serious ones that are out there, and everybody at the Commission, really across the boards, I think there's a lot of unanimity about this, wants to get to the bottom of what enhancements should be made to what are the strongest, most resilient markets in the world. So, there's a lot of momentum to have these not sit on the shelf. That's the whole purpose of that structure.
Good. Well, I hope that's the case. There's some concern here that.
Yeah, I understand.
Moving on, another question. Earlier this year, Representative Meeks and I sent you a letter regarding the reimbursement of Section 31 fees by the Commission that have been overpaid by an SRO. In response, it was noted that in January 2011, SEC issued a reimbursement to Nysiarca when it was operating as the Pacific Exchange. I wonder if you could explain why another exchange such as Chicago or NASDAQ is not entitled to the same treatment under the law. I know the Commission has maintained the statute requires clarification, but it's clear that the Commission has already established a precedent.
And again, the earlier incident occurred, or the earlier situation occurred before I was here. The status is we're still waiting on word, really, from OMB and Council as to what we can, if we can do this without a legislative fix. In terms of what was done earlier, I really can't talk, I can't speak to, I shouldn't say can't talk about, can't speak to what the analysis was there, but the current analysis is we're not certain we have the authority to return those fees. But we want, I would like to have the authority to return those fees.
It certainly seems like precedent is there, and at least here, where there's bipartisan support of, to me, this is,
Understood.
again, just a fairness issue and is significant in some of these situations. I mean, not in the scheme of things, but again, for these
No,
specific
absolutely,
places it is.
absolutely.
And so, again, would appreciate your help in moving this forward and getting it done. Moving on, March 25th, 2015, the SEC proposed amendments to Rule 15b-9-1 that would require additional firms to register with FINRA. During a speech on September 14th of 2016, you stated that the rulemaking would be finalized in the near future. While I share the Commission's goal for proper oversight of the securities market, there are concerns that the rulemaking does not adequately contemplate the impact on the option market and its existing regulatory structure. I wonder if you could provide an update on the status of the rulemaking. We're short on time for this hearing, but this is something I hope we can continue to discuss.
Yes, what the status of that is that the staff is, among the comments, very carefully studying the impacts in all areas on that. It is moving along in that analysis, but there's not going to be, I don't think, an imminent adoption.
Okay. Earlier in this hearing, you mentioned to Congressman Nagelbauer, when he was having some questions and discussion with you, that you had formed a working group, the SEC, to make recommendations to the Commission in regards to some fintech issues. Can you please tell me when this working group will make recommendations to the Commission, and then what questions you've tasked them with answering?
I can't give you a precise time on that. I mean, we've done extensive outreach. Obviously, our FinTech Forum was an important part of that, but we're still doing still extensive outreach, encouraging, for example, the participants yesterday to continue to engage with us. So timing-wise, it's not, again, I wouldn't call it imminent. And what I've tasked them to do is really across the FinTech spaces that touch on SEC functioning to make recommendations as to, concrete recommendations as to what the Commission needs to do. Whether it's rulemaking, and I start there, but that's not, kind of the primary focus. If that's the answer on the recommendation. Do we need to clarify to entrepreneurs what they need to do? Having in mind the lens of, this innovation can really help the markets and investors, and so we want to be encouraging of that, obviously balancing the investor protections. So we could have concept releases, we could have, interpretations being made, staff guidance being issued, conceivably a recommendation for rulemaking, conceivably just messaging more clearly to entrepreneurs what their existing requirements are. At the end of the day, we could end up saying, we think our existing system of regulation is adequate, at least in part, to these issues. So very exciting space, lots of potential, and I think we're doing it the right way.
My time's expired. Again, thanks for your service. I would echo Congressman Nagelbauer, and I do think any future policymaking from the Commission certainly would benefit from industry input, especially in that fintech area. With that, I yield back. Thank you, Chairman.
Gentleman yields back. Gentleman from California is now recognized for 5 minutes.
Mr. Chair, I would have one request, and that is when we put up the $19.8 trillion graphic, we add below it plus $1 trillion for President-elect Trump's infrastructure program. Madam Chair, on my request, I have one of you. I recognize your hard work. I can recognize you crossing off the days till your extended and well-earned vacation. The tradition is for the SEC chair, as I understand it, to resign when the new president takes over. But that tradition was developed at a time when we had a more efficient Senate and a more efficient Congress in general that could quickly confirm your successor. And that tradition was developed before the chair sat on FSOC, which should not have an empty seat. So you now have 2 very important seats, one at FSOC, one at the Commission, and I would urge you to consider staying on until your successor is confirmed. I'll just ask you to think about it. I don't need a... Now turning to more immediate, or rather more mundane business, you've still got pending proposed Rule 30E-3. The only folks in the financial services industry that can't provide information electronically are the mutual funds. They promise me that if you pass this rule, you'll save 2 million trees every year. On behalf of those trees, can you move the rule?
I'd indicated earlier, although obviously I'll be talking about the agenda with both my fellow commissioners, as I always do, but that's one of the areas where I'd indicated that we would hope to get a recommendation by year end on that. So,
Please inform me electronically of what you're able to do.
I shall.
Okay, as to small business investment companies, the House Appropriations Committee has asked you to reopen for comment your proposed rule in that area. Do you see you reopening that comment?
Sorry, I didn't hear what area?
That's in the area of BDCs, small business development companies.
In terms of that, I mean, again, the staff is, sort of constantly working on what should be done in that space to modernize, but I don't think we are, I don't know if we're reopening a formal comment period on that. I need to get back to you on that because I'm not precisely sure what you're targeting.
Yes, as I seek.
And I've written about that issue, obviously.
As I seek money for things that are important to my district, I look
Fair
forward
enough.
to showing the Appropriations Committee that I brought up their
Understood.
issue. Final issue. Accounting and auditing consists of defining the terms with generally accepted accounting principles and then auditing the information. And we do a great job of looking at numbers like revenue, expense, assets, earnings per share. So we have a whole system for those numbers. Now there are a bunch of other important numbers. I'll give for, might be the backlog of a manufacturing or aircraft manufacturing company. It might be same-store sales. And I wonder, in your closing days or perhaps for your, on the to-do list for your successor, if we could have a project to do the same thing that we do for the numbers in the financial statements, for the numbers in the what I hope would be a supplemental audited disclosure relevant to certain industries. Because when I look at Macy's or Nordstrom, the most important number might be earnings per share. Great job, clear definition. They can't change the definition year to year within the company. It's comparable between the two companies. And then I look at same-store sales, and it's as loosey-goosey as it gets. 100 years ago, we developed the balance sheet and the financial statement. Those were thought to be the most important numbers then. Can we move forward to have industry-specific, perhaps voluntary, perhaps required, supplemental numerical disclosures with generally accepted, which means SEC or delegated by the SEC defining, and have the public accounting companies that have spent 100 years just auditing 2 or 3 pieces of paper, audit a few of those numbers? Or are we in this bizarre circumstance where some of the numbers are audited and defined and some aren't?
I mean, to some degree, that's, correct, obviously. I mean, we've done a lot of work on non-GAAP measures, as you know, that are, not currently, audited, and they're, we've given a lot of guidance on that. I mean, sales stores, as I understand it, same-store sales, it would be auditable. There isn't a consistent definition. There's no question about that. I think in terms of sort of adding it to something that would be required to be audited, you'd have to consider, as you would in others, sort of the cost-benefit of that in terms of those figures. But I think, there clearly is not consistency in that space. It's clearly a metric that people pay attention to. So it's a point well raised.
Gentleman's time has expired. Gentlelady is recognized. Ms. Wagner.
Thank you, Mr. Chairman. And Chair White, thank you for appearing before us today to testify on the SEC's operations. And also I want to lend my voice to the chorus, thanking you sincerely for your service as you prepare for whatever comes next. And we wish you all the very, very best. With the election results from last week, there's been a lot of discussion and strategizing about the prospects of the Department of Labor's fiduciary rule, one of my favorite topics, as you well know. So I wanted to ask some questions regarding that as we look forward to next year. Earlier this month, Chair White, Merrill Lynch announced that it would no longer allow its customers with commission-based IRAs to purchase mutual funds. Already, choices are being taken away from customers. Are you at all concerned, ma'am, by the impact on the retirement services markets that the SEC oversees and regulates?
Well, I mean, I think we're probably all concerned about anything that results in depriving retail investors of reasonably priced, reliable advice. I think we've had that discussion before in terms of our own, thinking about a fiduciary duty rule. So, I mean, markets do adjust to, to rules in ways that sometimes have effects that are not desirable. We're obviously talking to where we overlap various effects of the Department of Labor rulemaking, and our job is to, coordinate as best as we can, provide relief if we have the authority to, and it makes sense to kind of minimize impacts. But that's one of the impacts that, again, Department of Labor certainly asks a lot of questions about, we've talked about before.
Well, Merrill Lynch certainly isn't the only company to announce major changes to their business operations, including even selling off of entire businesses. Are these impacts of the DOL rule being considered by the staff at the SEC as they develop a proposal to establish a uniform fiduciary standard, ma'am?
The answer is certainly that data will be considered. The status of the SEC is that the staff has provided a detailed outline of how it would approach what is a very difficult thing to do, and certainly to do well, to the commissioners. I don't expect that there's not. And as I think I've said before, I'm one vote on this, and so I don't think there's consensus to move that forward in the current commission. But, it is definitely something that, continues to be studied. All impacts, and most especially impacts like that, are being considered.
Well, and to that point, has the SEC undertaken a specific analysis on the impact of the DOL's rule on investment advisors registered with the SEC?
The answer is that that is part of the analysis that's done continuously, actually. There's not a specific sort of project for that, but clearly before we would move toward a proposal or a rule, it would be quite definitively studied, but it's also being studied as it happens.
Earlier this year, before the Capital Markets Subcommittee, David Grimm, the Director of Investment Management, stated that an analysis of the potential impacts of a uniform fiduciary standard was ongoing in preparation to draft a recommended rulemaking, but made clear that, and his quote was, "Whether a rule is ultimately proposed and adopted depends on further analysis and action by the full commission." Can you provide the committee any update on the staff's, as I push towards this analysis and some closure on this, of an analysis of the proposal's impacts?
Again, I think analysis is ongoing all the time. Obviously, everything's up to the full commission eventually as to, what rule to do, if any, and what the contents would be. Often when we do rule proposals, we do significant economic analysis, and then we do even more analysis before we decide whether to move toward adoption. I don't know if that's what he's referencing or not, but it's a continuous process, and you certainly complete that process before you would do any final rule.
And time frame at all? I know that your tenure is coming to a close, but where
I mean, look, this is something that, as again, I've tried to make clear. We would do this if we did this under 913 of Dodd-Frank.
Yes.
It has certain parameters in it. It's a really hard, complex rulemaking. I am one vote, and I think it's very important to do. But it is something, I don't expect there to be action while I'm still the chair. And I think in this current commission, you won't see that advanced. I mean, we're a commission of 3, so.
I understand.
Okay.
And certainly, I also agree that the jurisdiction of the SEC in this space is what is very preeminent and important vis-a-vis Section 913 of Dodd-Frank. I would just encourage you, as you come to an end of your tenure, that you make sure that asking and imploring them that the analysis be publicly shared, and if not publicly, certainly that it is shared with this committee before there would be any proposal of a uniform fiduciary standard. Thank you.
It certainly would come out with a proposal if there was a proposal, yeah. But I hear what you're saying.
Yes, just the analysis as we move forward. So I thank you, Mr. Chair, and I yield back.
Thank you. The gentlelady yields back. Gentleman from Connecticut, is recognized.
Thank you. Thank you, Mr. Chairman. And Madam Chair, let me join my colleagues in congratulating you and thanking you for your service chairing the Securities Exchange Commission at a challenging time. Two questions I wanted to ask you. As you'll recall, on July 15th, 9 of us on this committee sent you and the chairman of FINRA a letter about the persistence of the more or less 7% IPO gross spread, drawing on the work of Professors Abrams and Jenkinson and Jones, and asking both at the SEC and FINRA to undertake a study of the consistency of this pricing. It's relevant that we were all supporters of the Jobs Act, and we were motivated because, of course, the Jobs Act, which you certainly lived through, was estimated to save companies $1-2 million a year in Sarbanes-Oxley compliance cost. And of course, the average IPO at roughly $100 million, 7% gross spread, that's $7 million right there, and a remarkably consistent gross spread. So we have not heard back from either SEC or FINRA, and I'm wondering if we can get a sense of whether this is of interest to either and how we might proceed.
It is a point of significant interest. I think it's, and frankly, you should be getting a letter soon. I had checked on the status of it, so I think there are, I will say this much, as I understand, and I before you'll get the response, I always study it with the staff who've been studying it. There's some complexity in some of the data in terms of some of the cost information that kind of makes it hard to use it as sort of a straight line. It's 7% for, reasons that aren't necessarily apparent and may vary across those that charge that 7%. Again, I don't want to get ahead of the letter. And so there may be difficulty studying it, at least in a simple way, in a straightforward way. You've also got interacting in all of the space, kind of the changes of the Jobs Act that were made, whether it's the IPO ramp and some of the other, changes that have been made. So you've got a lot of factors interacting. But I think you raise a very important point and concern. So we should be getting back to you, certainly in my tenure, but I think very shortly in my tenure.
Great, thank you. I appreciate that. I mean, at the end of the day, we're just sort of asking for some scrutiny here. It may turn out that this is
understood.
Sort of an oddly consistent pricing in a free market, or it may turn out that it's not.
No, absolutely.
Great. My other question. There were a number of legislative proposals to define finally in statute insider trading. I'm partial to my own H.R. 1625, responding obviously to the Second Circuit's decision in the Newman case, which, as you know, has led to any number of convictions being overturned, some uncertainty for prosecutors. I have struggled to get either justice or any of the regulators or anybody to say that one simple way, of course, to remove some of this ambiguity, and I fully understand, and we've talked about this, that there is a vast body of case law, et cetera, but it does seem to me that clarifying the definition, at least, of insider trading and giving our enforcement mechanisms and the judiciary some clarity there would make some sense. But I've struggled to get sort of an affirmative agreement from either SEC or from the Department of Justice on this. And so I'm wondering if you can give me a perspective on that question.
I can try, and I know we've discussed this before, and I think yours is a very thoughtful bill. I mean, I think one of the concerns is the kind of various permutations of what the courts, the SEC, certainly would consider to be illegal insider trading, and defining that precisely is a challenge. Commissioners tried to do it, or thought about doing it, some time ago by rule as well. And again, I think we're in a little bit different position than the Department of Justice with respect to Newman, because it has less impact on our program because we have a lower burden of proof on that issue. We're obviously watching very closely what happens in the Salmon case that's before the Supreme Court on personal benefit. I think what I indicated before is, we basically have been arguing in our cases quite a robust insider trading program, including in the Newman spaces that it impacts, significant decision, but in narrowing Newman to its facts, been pretty successful so far. The Salmon decision on personal benefit, which is part of Newman, if that, hopefully from the enforcement point of view, that, comes out in a way that does provide a reaffirmation of what's required and not required to prove that element. But I think we revisit the question of either by regulation or by statute, do we need a clear definition of it, and then what should that definition be? But I think right now we've done well, I think. I mean, again, it's a consequential decision in our space too, which we worry about in terms of Newman, but, and then if Salmon comes out in a way that reaffirms what we expect it to, we think the state of insider trading law is such that we can continue to vigorously enforce it.
Okay, great, thank you, and I yield back, Mr. Chairman.
Gentleman yields back. Gentleman from Pennsylvania is recognized. Mr. Ruffus.
Thank you, Mr. Chairman, and I think that exchange just had with my colleague, Mr. Himes, is a testament to your professionalism that you've had before this committee and the knowledge base that you bring with you, that you've accumulated over your career, and I just want to commend you for that and your 20 years of public service, and more than 20 years of public service. I want to do a little bit of retrospection. I know some of my colleagues are focused on the next couple months and potential regulations coming down the pike. I want to take a little bit looking at what FSOC's been doing. The FSOC, with the backing of the SEC, has wisely taken an activities-based approach to evaluating systemic risk in the asset management industry. Many of us on the committee would like to see this approach applied to the insurance industry as well. Can you explain why the FSOC has applied an activities-based approach for evaluating systemic risk to asset managers but not insurers?
You know, again, FSOC has the option to do either, and I think what has been said by FSOC on the asset management space is they don't rule out, you know, coming back to the consideration of a designation of firms in that space. But I did, you know, clearly I think the pivot, as it's sort of referred to in the asset management space, to activities made good sense in that space. Lots of the analysis on the insurance industry actually preceded my actually being on FSOC or at the commission. It was very thorough analysis in that space, and I think FSOC is, and I think is confident with respect to where it landed there. But I fully understand the question and the argument that's being made. But I think the lens through which they looked at the insurance industry was, under clear authority to look at it in that particular way, and they were confident in their analysis there. So you might get a slightly, I think that's a pretty accurate assessment of the thinking.
Also, with respect to insurance, I'm a little curious about SEC's role as a member of both the FSB and the FSOC. As you know, there are concerns about the extent to which the FSB's systemic risk designation process for non-banks is separate and distinct from the process the FSOC uses to designate non-bank SIFIs. Fed Chair Yellen, who testified before this committee in September, argued against any allegations of FSB front-running based on the assertion that GSII SIFI designation timeline for MetLife and Prudential was inconsistent with that narrative. Do you recall whether it was the FSOC or FSB that first designated these non-banks as systemically important?
Again, this either precedes me or it happened about as I arrived, I think. I think I should get back to you. I think there was designation by FSB earlier, but I'm not sure of that. I'd have to get back to you on that. I mean, the processes are separate. I mean, I was actually recused on some of the insurance companies, so I'm less familiar with it. We also, the SEC staff, which does participate extensively in FSB committees, if the subject matter of what's being considered in FSB doesn't relate to the securities markets, we don't actually participate actively in those work streams at the FSB. I can get back to you with what information we do have on it, though.
We may want to follow up with that. But
sure.
In your role at the FSOC, have you felt any pressure to enact FSB policies or designations domestically?
None whatsoever.
Okay. I yield back, Mr. Chairman. Thank you.
Gentleman yields. Gentlelady from Wisconsin is recognized.
Thank you so much, Mr. Chairman, and thank you for your service as well. And thank you, Honorable Mary Jo White, for your service as well, and I wish you well in the future.
Thank you.
But you're still the chair
I certainly am.
So we want to make sure that you use every single moment in your office to bring about the results that I think American people knew. We have gone through some rough times in this country, and one of those rough times was when our market funds sort of broke the bank, and there were rules floated, rules promulgated to float the NAV. And since then, we've seen $64 billion in lost funds regarding that. And so I'm wondering if you've sort of changed your mind about the efficacy of, particularly with our state and local governments not really having anywhere to put these funds that they need to keep liquid, that we're already centralizing money in all these large banks. And I'm wondering if you've had any further thoughts about floating the NAV.
The answer is, one answer is, and it's a very important one, is that we at the SEC continue to review the impact of all our rules. And one of the things I've done since I've been chair is to, as they come out of the gates, don't wait 5 years or 2 years to look at them and their impacts. And we've certainly been following that very closely. I will say that thus far, the impacts that have occurred were largely predicted in our economic analysis. For example, the money market fund space is, in terms of, in toto is about the same in terms of, volume size, dollar size, but a lot of movement to government funds, which we predicted. I think the diminution on the muni funds that qualify, they may be subject to the retail exemption and therefore not subject to the NAV, and obviously they're not impacted. A lot of that has to do with the low interest rate environment, and I think not the money market fund rules. Clearly, the real significant movement has been in the the prime institutional, where it does apply. And so, the answer I think to date, and again we watch it very closely, is that the benefit of the reforms that we instituted, we believe, was the systemic risk issue. That's obviously a large one and of great concern. And I think that is something that we're confident that we have the confident, subject to further analysis, that you needed to have the floating NAV for. I think, we think, possibly, watch it closely, you'll see some return of those funds to, the prime institutional space over time, but we have to, see if that happens.
Well, right now it's not happening. The SEC put out a report in 2012 on the municipal market that included a lot of recommendations, including providing the SEC authority to directly regulate muni bond disclosures. Now, you've been supportive of this report in the past, but in light of the MCDC initiative, where several issuers were fined for disclosure violations, do you think we need to do more in Congress to move on these recommendations?
I think it's a broader issue than the MCDC, because that was really continuing disclosure obligations, and as we have obviously less direct authority in that space than we do for the public company sector. I think the MCDC was enormously effective, and it obviously had, we tried to carefully calibrate that so that we were mainly aimed, particularly for issuers, at really changing the conduct there and improving the disclosures. And so we really tried to be very measured there. The underwriters measured also, but obviously there was a different settlement paradigm for them. We've seen improvement in those disclosures, but I would not conclude that therefore obviates necessarily the need for greater authority for the SEC. That's something that the staff, is, again, it's a continuous process, but we'll be looking at and is looking at sort of continuously. So we may speak further on that in the future.
Well, thank you again, and thank you again for your service. And I hope that you stay floating somewhere on the fringes so that we can have someone to call.
Thank you very much. Thank you.
I yield back, Mr. Chairman.
Gentlelady yields back. Mr. Tipton, recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you for your service as well, Chair White. Thank you for taking the time to be here. I'd like you to be able to expand maybe a bit, if you would, on the sandbox regulatory framework in regards to innovation, being able to provide access to capital. And is it your sense that the SEC should take the lead in developing regulations for the Financial Technology Center and encourage a flexible regulatory structure to allow for experimentation and innovation within the fintech world?
There's several questions in that. I think I am supportive of the SEC, asserting its jurisdiction in spaces that we're in. I think it's important to do that. We're doing that in consultation, coordination, cooperation in the Treasury markets as well. So I think we do a good job in those spaces. So I think we should be asserting our authority there. I also think that where we come out is yet to be seen on various issues, which is as it should be, I think. And I had mentioned earlier that I'd set up a fintech working group some time ago to among other things, tasked them to come up with recommendations as to how the SEC should proceed, clearly having the lens of, this innovation is exciting and can yield tremendous benefits, and we don't want to be stifling in what we do. We obviously have to be concerned about protecting investors and everything that we do as well. So I think we have the right group working on it. I think we have the right mindset working on it. So.
Good. Yeah, I was a little concerned when Comptroller Curry had made a few comments that seemed to indicate it was a little more of a one-size-fits-all, so I was heartened to hear your comments a few moments ago saying that one-size-fits-all is not the best path, oftentimes.
Yeah, I mean, again, just to be clear, I mean, obviously, at the end of the day, we have to make sure investors are protected in whatever we do, but I think it's something that we have to, really look at with fresh and open eyes and open mind.
Going a little bit to some of the forums that you'd held earlier, and understand you're gathering the recommendations, and from those forums, what was your sense? What's the big challenge that small businesses are really facing?
I mean, there are a lot of challenges that small businesses face, which I think all of the regulators need to be very focused on, and I think we are at the SEC. I mean, you obviously have a lot of startups in the spaces that we're looking at, whether it be automated advice, and I think one of the, I was watching one of the panels, I mean, one of the predictions is that we're going to have more consolidation of automated advice givers, also known as robo-advisors, but they'd like that to drop from the lingo that's out there. And you worry a bit about those smaller, maybe high-quality advice givers that, may find it too difficult to really sort of penetrate the market space. I mean, we clearly are of the view that, registered advisors, whether they're automated providers or in part automated providers of advice, are subject to fiduciary duty rule, have to comply with those obligations. But I think one of the things we're doing in our national exam program, that's a priority for our exam program, to see sort of across the industry, how they're carrying out their responsibilities. And what we try to do from that kind of exam is then to share kind of the learning, frankly, and hopefully that helps some of the smaller outfits, but you can't tell yet. I think it's a little too early to predict.
And you may not be able to fully speak to this because I know you're reviewing the recommendations, but did you have a sense coming back from the private sector that being able to have flexibility, to be able to streamline when we're talking one-size-fits-all, the multiple costs that are associated with redundancy and regulations, that was something that the private sector was really wanting to be able to encourage?
Well, I think the private sector encourages it. I think whichever sector I'm in, I think this makes sense. I mean, sometimes one size fits all in a certain range. But most often, if you have the ability to do it, you want to tailor regulation to the particular problem.
And I guess just kind of final, you wear a couple of hats, but with the FSOC that you sit on, would you support the Fed's attempt to usurp the SEC's jurisdiction as a regulatory agency over the capital markets?
No, I would not, but I don't think they're trying to do that, at least since I've been here.
Okay, great. Thank you so much, and thanks for your service. Thank you, Mr. Chairman. I yield back.
Thank you. The gentleman yields back. Gentleman from Maine. It's Maine, right?
Yes, Mr. Chairman, it is Maine.
I'm coming to Maine. I'm coming to Maine.
Everyone is going to Maine after once.
I knew he was going to ask me.
We can restart the clock and give him an additional 30 seconds to speak about Maine.
I'd appreciate that very much, Mr. Chair, and thank you, and Chair White, thank you very much for being here. Your retirement from your great service to our country, and thank you very much, also does, Mr. Chairman, provide an opportunity for you to vacation more. And Maine, as you know, is vacation land, and it's also a great place to buy a second home, and we'd love to invite you as being a taxpayer up there too, Chair White. So either way would be just great. Now
you're going a little too far.
I did want to cover three issues very quickly with you today, Chair White, if I can. And we've talked about a couple of these already, but of course, your mission that you folks pursue over there very aggressively, and I appreciate it, is to make sure our small investors have the information they need to make the conscious decisions, the important decisions to prepare for their retirement nest egg or college savings or what have you. Now, you folks in Rule 30E-3 made a decision not to move forward with this rule, and I am very grateful. Thank you very much. And for two reasons in my case, Chair White, is number one, we have a highly rural district in Maine's 2nd district. And there are a lot of folks that are not connected to broadband. We have a problem with cell phone coverage in many parts of our district. Now, there are 60 million Americans that live in rural districts. In addition to that, there are about 46 million who are seniors 65 years and older who have a hard time navigating the internet. So it is critically important to make sure that our senior savers and our savers and investors in rural districts have the information that's so critical to make the decisions they need. Now, also, full disclosure, Chair White, we've had this discussion, is that we make that paper in Maine. This very fine paper that these mutual fund reports are printed on up at Twin Rivers and Madawaska, way up along the Canadian border. 600 terrific jobs, and I advocate for them all the time. Now, I know a lot of the Wall Street firms, want to forego the cost of buying the paper and printing on the paper and sending it out to investors. However, our investors need this information if they have no other way to get it. So I am pleased and grateful that you have not moved forward on Rule 30E-3 that would make it more difficult for our seniors to receive this information on paper. So my question to you is the following, Chair White. Why don't you just withdraw the rule?
What I said, and we've discussed this, I know, but what I've said, I said at the time we actually adopted the rest of the proposal for investment company reporting, was that we got an extensive, important comments along the lines that you've just made, that I directed the staff to study further and then come back to the commission, basically targeting year end to come back to the commission with a recommendation after that was done. We were also looking at the, who's paying the bills, to try to get better cost data. So that undertaking is quite actively proceeding, and it's something that I think, again, the comments I think were well taken, needed further study. I can't tell you where the commission comes out ultimately or precisely when.
The decision will be made, if I understand you correctly, you expect by the end of the year before you move on to your...
again, I've spoken publicly. I did at the open meeting we were targeting year end for that.
Okay. Let's move on, if I can, to a separate topic. We don't have a lot of time dealing with the role of FSOC when it deals with asset managers, and I know a couple of questions have already been asked of this, Chair White. You and I may disagree on this, but if we both run pension management firms, and I hate to say this, but my performance is better than yours, then your clients will come to my shop, but the assets are held over here at French Hill's custodial bank. So if your firm gets in trouble, it represents no systemic risk to the economy. That being said, and also, Chair, the fact that you folks have already adopted a new, more aggressive series of rules to make sure you aggressively examine our asset manager community, and you folks are the primary regulator for pension fund managers and folks that run college savings plans, why don't you just recommend, if I may suggest, to FSOC that you take the potential designation of asset managers as too big to fail just right off the table? Do you need it anymore?
And look, I think, FSOC's responsibility, and look, I do think it's an enormously important safeguard to our financial system to have FSOC there. It really is to kind of continuously address risks, emerging risks, possible risks down the pike. So, taking things off the table, I mean, you really are sort of charged with continually looking at it. Having said that, clearly there was a significant pivot to activities, which made sense. We've obviously done rulemaking since then, but I think FSOC's efforts, as they certainly to date, are complementary of what we're doing at the SEC, not contradictory.
The concern I have, Chair White, is that, of course, if any asset manager that represents no systemic risk to the economy is so designated, there will be a whole layer upon layer of new regulations that will drive up the cost and drive down the rate of return of our small investors trying to save for college or their retirement. So that's why it would be terrific if you could use your influence during the last couple months you're with us to make sure they get the message over there at FSOC, and I really appreciate it. And again, congratulations. We will be looking forward to welcome you to Maine whenever you find that to be the right time. Thank you, Mr. Chairman. You're back my time.
Gentleman yields back. Mr. Hill is now recognized for 5 minutes.
I thank the chairman, and I thank you, Chairman Garrett, for your service in this Congress as chairman of our Capital Markets Committee. You've done an outstanding job. And Chair White, it's a pleasure to see you. And as someone who's testified before Congress before, I always thank you for your forthright testimony. It's a relative statement compared to many who come before us. Sometimes the bar is relatively low to step over, but I really do appreciate your effort to be responsive to the committee in a timely way. The market structure topic, we've talked about that before, and this is something that in the first term that I've had in Congress over the last 2 years, it's concerned me because we have some 50 trading platforms, and we've added recently a new exchange. And when the Commission published its list of rules that would be reviewed pursuant to the Regulatory Flexibility Act, it included regulation NMS. And where are you on your commitment to fully vet and review that rule?
I mean, NMS is, I mentioned before that at least as I look at our market structure work, it's both things that we know now we think at least should be fixed, and it's a comprehensive, review of, all the relevant issues. Obviously, one of the biggest relevant issues is NMS itself, and that's something that both is, something that's the subject of our MSAC committee's work and also, of the SEC's comprehensive review. I mean, there are a lot of pieces to that. One of the reasons we want to be data-driven in the market structure work is that we don't, we do have the safest, most reliable markets in the world and strongest, I think, and we don't want, to do something that, would have unintended consequences. But in terms of examining NMS, from the ground up, it's very much on the table to do.
When do you think the Commission will review their work and make a proposal there?
With respect to NMS itself, I can't really predict the precise timing. I mean, I guess it may be up to somebody besides me in terms of actually when it will be, before the Commission. But I'm sure it will be. Well, I shouldn't say I'm sure, but I would expect it to remain, front and center going forward.
So, this issue between trading venues and exchanges is a related topic. I think it all relates to us having the most competitive markets and having the most competitive, particularly equity markets. I noted that former Commissioner Gallagher gave a speech not long ago where he talked about should exchanges remain self-regulatory organizations, SROs. In your work as you head out, have you developed a personal view on that?
I mean, that's something that, we continue to say. That's also, I will say, in one of our subcommittees, it's very focused on it. We continue to do work on it. I haven't formed a view on it other than that I think there's significant questions raised.
I want to switch gears briefly, and it's something that I think Congress has reaffirmed over the past years, and certainly the Commission has, and that's the issue that for equity research, one can use so-called soft dollar commissions to pay for investment research. Is that still the position of the Commission and under 28E, for example?
There's not a prohibition on that, right?
Yeah. So, but I hear that in Europe, they're headed a different direction under their 2014 proposal they put out called Markets and Financial Instruments Directive. Couldn't that create a real disparity for U.S. investment banking and research firms for their clients in Europe versus their clients in the United States?
It certainly, has that potential. And I mean, one of the things that's, it sort of struck me that certainly the first week I entered the door is just how much we need to be coordinating with international regulators for, certainly among the reasons, the ones you're just teeing up right now, and it's something we do consider when we decide, our own policies as well. I mean, you're looking at, how do you coordinate two different systems? Who is it advantaging, disadvantaging? And so, it's something we continue to discuss with them in various forums, actually.
Would it be something you'd be willing to write a letter to the European securities regulators and caution them about this because of the disparate treatment that our investment research companies would?
I mean, I think I'd need a little further briefing on that from the staff as to exactly, at least in their view, how they sync together or don't. But certainly if I was of that view after that, I certainly wouldn't hesitate. I might not do it by letter, but,
You have time. It doesn't take place until
I do have
18,
time.
but in 17, you know how firms work well in advance of deadlines, and I think it could put American companies at a severe disadvantage. Thanks for taking a look at it for me. I yield back, Mr. Chairman.
Thank you.
Gentleman yields back. And I think the gentleman who's going to have the last word on this entire matter, Mr. Barr.
I'd like to join my colleagues in also thanking our chairman of the Capital Markets Subcommittee for his leadership. And Chair White, thank you for your service as head of the commission and for sharing your expertise and your insights and helping us with our oversight responsibilities over the commission over these last several years. I want to focus on the part of the commission's mission, statutory mission, to maintain fair, orderly, and efficient markets and facilitate capital formation and follow up from the questions from my colleague, Mr. Royce, regarding fixed income markets. As you know, significant attention has been devoted to liquidity concerns in fixed income markets, both in the U.S. and globally. And when you last testified, I believe, in front of our committee, and when you were asked about the regulatory impact on liquidity and illiquidity that we're witnessing in fixed income markets, I think you testified that there's no question that there are concerns about the liquidity in fixed income markets, but that you could not identify the culprit. And we've heard similar testimony from the Treasury Secretary who denies that regulations, Volcker, risk retention, Basel III can be pinpointed to blame here. And yet we continue to see, since your last appearance in front of our committee, evidence of regulatory impacts on liquidity. September 27th, former Treasury Secretary Hank Paulson commented that the Volcker rule solved a problem that was not a problem. We have much less liquidity in the markets. It has become much harder for financial institutions to provide liquidity. That's his testimony. And then you had a CEO of one of the world's largest electronic market makers announcing that his firm would no longer invest in certain bond exchange-traded funds because of underlying securities have become too hard to trade. And then on October 7th, the value of the British pound plummeted from $1.26 to $1.18 in a matter of minutes during trading in Asia, with some electronic platforms recording trades below $1.15. The Wall Street Journal attributed this extreme volatility in part to a lack of currency traders in the foreign exchange markets. So given some of these more recent developments, have you been able to determine whether regulations, Volcker, risk retention, Basel III, are in fact impacting this illiquidity?
The answer to that is no, we don't have the evidence to make that finding. I think there's also some differences of opinion as to whether you've actually had the deterioration in liquidity that, you're basically a number of market participants are noting from the data that we have available. I mean, one of the things that, because I sort of constantly go back to the staff and say, here's what the data looks like. We report quarterly to this committee and to several of us in the regulators, primary liquidity, secondary liquidity in the corporate bond markets. And, whereas you clearly have some deterioration if you use the measure of dealer inventories, that's the other measures really seem to be holding pretty constant. We obviously had some impact from Brexit, but that seemed to recover. And so one of the things that is possible in terms of why are the two different views out there is most of the liquidity measures are based on completed transactions. Now, there can be transactions that don't get completed because you don't have an available buyer or seller. And so it's kind of a speculative thought, I suppose, but it could be that, some of what isn't being measured is actually transactions not being consummated, as opposed to ones that may take a while to consummate. So there still is a different, bottom line is, no, we don't see that impact in the data, and we don't see the deterioration that others see in the data that we have.
But there is evidence out there. So, for example, when the CEO of Blackstone says, when they passed Volcker, there were 25 firms making markets in junk bonds. Guess how many there are now? 5. 25 to 5. Triumph, you decide. What happens when things get difficult and the market now just locks up? That is not healthy for capital markets, and this is happening all over. It affects all markets, and liquidity is coming down because we mandated that to make the world safer. But this does not make the world safer. This is encouraging the world to be this is not encouraging the world to be safe, because when people need to sell and there isn't liquidity, what happens? So. Reaction to that?
No, and look, I think on that score, again, I think that's the dealer inventory metric I was just talking about, but under Volcker, you also have the market maker exception, right? So that you can have, banks basically acting as market makers that's still permitted, so that can be a source of liquidity. But look, I mean, just sort of stepping back, I mean, these are significant concerns. I mean, but, as I say, and we study it globally, we're studying it, domestically we're studying it, getting all the available data that we can, and really staying on top of it. Our economists at the SEC are actually directed to report to Congress, I think in May of 2017, of the impact of regulations collectively on corporate bond liquidity. That's part of what they'll be reporting on. It's a hard thing to do, hard thing to ferret out also, hard thing to measure.
My time has expired, and you're exiting your post, but I would encourage your successors at the SEC to continue to evaluate that, particularly in their role as a member of FSOC. Thank you. I yield back.
Thank you.
So there's a lot of other members out in the antechambers. They're just waiting to come in at this last minute, because I was told that you, unlike many other members who come on this panel, did not have a hard stop date, so it's just going to keep, it's not.
So I just might as well, sleep here right now, it's okay.
So that concludes today's hearing, and let me once again say thank you for your service. Someone made the comment, and I don't think it meant to come out that way. They said they thank you for your service and it's relative to the others here. And it is true that the bar for the other people here is pretty low, but you certainly have greatly exceeded that by the breadth of the breadth of your expertise and your dedication to public service in this position specifically. So I personally thank you for what you have done. Although I'll say at the very beginning with the but on those areas that we disagree on.
Understood, and thank you for your service as well.
Thank you. So with that said, without objections, all members have 5 additional days to submit additional questions, which will be submitted to you. So you have, and we ask always that those be returned promptly, and you still have X number of days to do that in. So there you go. And also, without objections, all members have 5 legislative days to submit extraneous materials to the chair for inclusion of the records as well. And with that, this hearing is adjourned.
Thank you very much.
Thank you.